May I be allowed to mention, my lord, I'm the appellant in person, my lord. I had filed a revocation of the probate before the single judge below, and the application was admitted. The other side, the alleged executor was directed to file affidavit in opposition. They have filed it. We were allowed to file reply, which is due on 29th of this month. And there was an amendment which just completed on 18th of July. Now, in the meantime, they have filed another application seeking certain medical documents from the Apollo Hospital in terms of a writ petition, where the stay has already been given. And my humble submission was that let me file an affidavit in opposition. It happened on last 18 July, Friday. So I have filed my affidavit in opposition on Monday, but without seeing my affidavit in opposition, the interim order has already been passed. So
have you filed an appeal?
Yes, my lord. I have filed the appeal yesterday. My affirmation has been done. So since it will take time, so I pray for you for the liberty to be heard. Then I will file it once I get the liberty. It is with me. The affirmation, everything is completed. I had sent my person to serve it yesterday.
File it, sir.
My lord, if the liberty be given to be heard, because they say that our processing will take our own time. So I thought, I'm praying for the liberty.
Liberty.
Because it will much obliged, my lordship.
May my lord's kind leave to mention a matter. Lordship, I'm praying for
yes.
Lordship, I'm praying for Lordship, I'm praying for inclusion in the list and appeal which is already filed before my lords. Lordship, I'm just praying
Inclusion.
Lordship.
Inclusion, hand over the slip. Just don't mention.
Deeply obliged.
May I have my lord's leave to mention a matter? This is, Lordship will remember the matter where Mr. Deepak Dev was discharged as the receiver.
Yes.
Mr. Shornendu Ghosh was appointed. He has refused.
But he didn't want to.
Yes. So,
yes.
Lord, we have spoken to Mr. Manish Ray of the Bar Library. So he has on terms agreed
to be mentioned.
To be mentioned. So that
to be mentioned.
Grateful.
Notify all the parties.
I'll mention.
To be mentioned tomorrow.
Tomorrow.
My lord, my humble submission is if it can be heard tomorrow, because the 7 days will end on Friday.
My lord, there is no urgency in the instant matter.
Sir, you supply the number, it will be listed, it will be heard.
Much obliged, my lord. Much obliged.
My lord, may I permit you to mention a matter? It's an appeal matter for non-prosecution in...
Yes, to be mentioned tomorrow.
Very well. I'm grateful, Your Honor.
My lord, may I have your lordship's kind leave, my lord, to mention an appeal from the
inclusion
determination of the Honorable Justice Sobhasati Bhattacharya and Joy Kumar that appeared in the list but could not be taken up.
Appeal from what?
My lord,
Order 41. Order 41.
Your lord,
what is the urgency?
The urgency is that, my lord, the plaint was rejected by the court below and the appeal has been preferred. But my lord, what happens, my lord, after service of notice on the other side by the respondent, the vehicle of the petitioner has been, my lord, taken away.
Already taken away. Very good. When was the order passed?
My lord, the order was passed, my lord, on, my lord, 17th of June. And the matter has been listed, my lord, before the Honorable Justice. And there... And the concerned bank is trying
to give it. Give it.
My lord,
yes, Mr. Benny.
My lord, this is an urgent matter of Justice Bhattacharya's.
When was the order passed?
My lord, last week of June, my lord, ad interim order was refused. My lord, we sought for injunction in respect of, my lord, a suit where specific performance, my lord, we are asking for.
When did you file the appeal?
My lord, this was filed, my lord, 7 days back. It was item number 10 before my lord Justice Bhattacharya.
What kind of injunction?
My lord, not to transfer the property for the present moment, because there is an existing agreement between the parties. My lord, they have given out.
But I'm next.
I'm paying
I'm
for
grateful,
this leave to move this matter as extremely urgent matter, the matter relating to land regarding demolition of structure. So this order passed on 15th July. So
Demolition of structure.
yes, ma'am. Regarding the PWD Act. PWD. Land matters.
And how do we have determination?
No, my lord, the determination of their lordship, the Honorable Justice Sabyasachi Bhattacharya and Uday Kumar. So
Are you there? Oh. Yes, why your structure has been ordered to be demolished,
yes, my
or
lord.
you want to demolish somebody's structure?
I want to restrain the authority to demolish. So there is no scope for demolition. The total land 78.
Lordship,
May I seek
I'm
one
seeking-
urgent leave to move this matter, my lord, tomorrow.
No,
My lord, urgency is that, my lord, petitioner is a owner of the house, and my lord, petitioner has a sanction plan. All petitioner have, my lord, deed and all the relevant documents. My lord, there is a order of single bench to restore the, my lord, water land. My lord, in the petitioner property is nowhere in the water land, but my lord, all of a sudden, my lord, the demolition process has start, my lord, and they are saying that my house will be demolished, my lord. One writ petition was moved, and my lord, liberty is given to the move to the LRTT. My lord, I have filed, my lord, date given in the month of August, my lord. In the meanwhile, the demolition process will be end, my lord.
So you have already approached LRTT, then how can you maintain this appeal?
My lord, I prefer an intercourt appeal, my lord.
But you have acted in terms of that order. You have approached the LRTT.
But my lord, LRTT is not considered my urgency, and my lord, give a long date, my lord.
So go before the learned single judge, say that.
My lord,
For interim protection.
I
You have accepted the orders, madam.
I came before your lordship in
No,
action.
no, sorry.
My lord, this is regarding my
My lord, I'm
Next,
seeking
next.
seeking leave
my
to
lord, kindly, my lord, consider my property will be demolished. My lord,
We are telling you, go before the learned judge and say that your lordship has granted us liberty. We have approached. Kindly grant us interim protection because the date given is August.
order is, my lord, disposed of. Petition is disposed of, my lord.
Wow. Sorry, we can't help you. Yes,
My matter will be taken up day after tomorrow, my lord.
day after tomorrow. ওনার ম্যাটারটা কিরকমটা জানিও না।
Lordship, I'm seeking leave to mention this matter. I'm respondent in the matter. The matter is running before the Justice Sabyasachi. So in this matter, but the property already injuncted. But the petitioner herein tried to sell the property. That's why urgency is that already injuncted property. They preferred an appeal over there.
Petitioner is trying to sell the property. You
Yes,
are the
sir.
petitioner.
No, I'm the respondent, Lordship. In this case, already can has been filed and opposition in reply also been filed.
বুঝতে পারলাম। Have you given notice to the petitioner?
Yes, Lordship.
Where? Who approached the learned trial court?
Petitioner. I am respondent in this matter.
You are the respondent before the trial court also.
Yeah, no, Lordship. Petitioner injuncted. No. Lordship, I have-
Sorry, you please find out and come back. You are not.
My lord, on application, my lord, order 41, my lord, on month of May, my lord, the matter was dismissed for default. Now, my lord, I have filed the restoration application. Meanwhile, what has happened, my lord? My lord, decree holder proceed with the, my lord, execution proceeding, and my lord, police help also, my lord, allowed. My lord,
When did you file the restoration?
my lord, April, month of April, month of June, June, my lord.
May it was. Which date of May? Dismissed?
Order, I have month of May, my lord.
There was a particular day, you don't know that.
No, my lord. I
Then don't mention. Yes, call the list.
We have petition item number 2 and 3.
মেনশন করতে গিয়ে তুই কিচ্ছু জানিস না।
কি হয়েছে যে আমি কি হয়েছে আমি
জানি না।
কোর্টে অনেক
Yes.
Well, this is that
I'm
application.
praying for a small Passover, your lordship, in this matter. Well, this was for drawing up of the decree, my lord, as last chance, my lord, had given, my lord.
Yes, yes, yes.
All passed
It has
away.
been done.
My lord, the settlement was done, my lord,
Yes.
the chambers, my lord, on the last occasion, and
Your client,
For 3, your lordship.
we don't know, excepting your client, nobody participated, nobody gave any comment yesterday.
The lordship,
No,
yes.
sir, Your Lordship, I'm appearing on behalf of the appellant number 1. I have commented and I have sent a letter.
Very well, it is on the verge of completion, adjourned for a week. Yesterday, the master personally saw me. Adjourned for a week.
much obliged, my lord. Will there be any recording?
28 years.
My lord, will there be any recording as a
Correct. গরম হয়ে গেছিল।
well, any recording, my lord, or
Yes, yes. 2 and 3 কি একসঙ্গে হচ্ছে? আলাদা আলাদা? We understand that the decree in question is on the verge of being drawn up and completed. Stop. Let this matter stand adjourned and be listed again on next Wednesday date or the other, under the same heading. Same order 2 and 3.
Item number 4. I'm for the this matter, I filed an application for the purpose of disbursement of the amount that was deposited by the appellant pursuant to the stay order that was granted by this honorable court. The matter got dismissed for default on 24th of April 2025. However, the amount, the arbitral amount that was deposited by the the appellant, that is still lying with the registry, in pursuant to
The matter has not been restored.
matter has not been restored. The matter has been dismissed for default.
Very well. You have served this application on the appellant. Where's your affidavit of service? For hand service? পেয়েছি। Who was appearing? Who was appearing in the
The
appeal?
advocate on record in this matter, we could not trace the advocate on record.
দাও তো ফাইলটা দাও তো।
Because of that, we had to make a hand service upon the applicant.
Ognishwar Bhuiya. You know him?
I am the advocate.
You are Ognishwar Bhuiya?
That the matter got dismissed for default. I have filed my.
এটা তো অ্যাপ্লিকেশন, এটা তো ওর অ্যাপ্লিকেশন। মেমোটা কোথায়? মেমো নেই? ও কিছুই নেই। লেখা ছাড়া।
The Lordship kindly take up my application.
Sir, we are going to ask you to serve once on the advocate for the appellant.
We are not able to trace the advocate even after several trials. We are not able to trace the advocate.
No, we will tell you. আমরা মেমোটা তো পাবো তো, মেমোতে থাকবে তো অ্যাডভোকেটের নাম। দুটোর ভেতর পেয়ে যাবে। Come back at 2 p.m. Mr. Indu Bhushan De.
We are not able to trace he is as per the address that we have got, the bar association room number 5, but we are not able to find him at that particular address.
তুমি মেমোটা আনাও, দেখা যাক। Come back at 2 p.m. let us see. হয়তো অ্যাডভোকেটের রেকর্ডিং সামনে। পুরো রেকর্ডটাই আনো। What is the amount that is lying?
Amount that has been deposited by the appellant, that is 42 lakhs.
That is the award amount.
That is the award amount. And apart from that, the Larnet Court directed the amount to be deposited in a fixed deposit. So interest will also be there.
So the authorities, 34 has been dismissed also.
34 has been.
Very well.
I don't know why.
Lordships, I appear for the respondent number 1, Lordship.
I appear for the respondent number 2, Your Lordship.
I am for the appellant. I am filing reply.
Yes, my lord, she is.
Lordship, on the last occasion, had directed for an opposition to be filed to their restoration application, Lordship. If Lordship will have a look at the last order, Lordship.
My lord, we have filed the reply itself just now, my lord. I'm just praying for the restoration, my lord.
Why are you on the virtual mode?
My lord, I'm outside of the city, my lord. That's why I had to.
No, we don't appreciate this.
My lord, kindly restore the matter and revive the interim order, my lord. Just this is the prayer from my side, my lord.
Respondent number 1. Seek the copy.
Who is going to argue the matter?
Proceed.
No, we can't. This very disturbed reception. We can't. Either you argue or we'll adjourn it.
Yes, kindly.
My lord, then kindly, I'm praying for a not today, my lord.
Yes, yes, my lord.
What are you filing? Reply.
Yes, my lord. And respondent number 2 has not filed any opposition.
You're number 2.
We haven't filed any opposition.
You are number
1. I filed my opposition, served them, Lordship.
affidavit in reply filed on behalf of the appellant in response to the affidavit in opposition of the respondent number 1 be taken on record. Paragraph on the request made by learned advocate for the appellant, comma, let this matter stand adjourned for the day.
My lord, deeply obliged.
Deeply obliged. एक रिसीव करके दीजिए मेरे को रिसीव करके
Suppose I should appear in that.
Ma'am, 1
But I'm in a predicament, my lord. Even after I have left my office, my lord, Mr. Sinha continuously in the morning sends me messages. I've received 14 briefs today, but all of state of West Bengal.
Yes.
This is two matters, my lord, both more or less similar, my lord. This is with regard to, my lord, according to them, my lord, money advanced and not repaid. My lord, they have said, my lord,
You are the appellant.
I'm the appellant. My lord, I've suffered a decree of 40 lakhs in one fine under chapter 13A. But the honorable judge, they had one set of oral agreement. My defense was also on an oral agreement.
Mr. Roy, you have suffered a decree?
Yes, yes.
Right.
But I will kindly admit.
Yes.
And Mother grants me some time to put in the whatever security.
Fortnight. Mr. Dotto, fortnight.
I have calculated in both the matters. If Mr. Ray is willing to put in that.
The principal is
I am entitled to under the degree. Till July 2025, I have calculated. I leave it to your lordship. I'll just permit me to hand up my lord the calculation.
We will just say decretal amount, whatever it is. Issue. Two suits.
Two separate suits.
The same you have. Acta 40 in 140 in the other.
My lord, with interest in the first one, 40, and interest, my lord, takes it to 78 lakhs. And in the other, my lord, principal is 10 lakhs. With interest, it's 19 lakh 50,000 as well.
Doubles.
That's the, my lord, agreement.
Memo, just memo.
All oral agreements, my lord. Never.
Interest paid at that rate.
This appeal is directed against a judgment and decree dated January 15, 2025. Stop. The defendant has come up in appeal. Stop. Paragraph. এটা তুমি ওই জিএটাই করবে, এটা জিএ আছে দেখবে, হ্যাঁ, অ্যাপিলার জিএ দুটো নিয়েই করবে, আলাদা আলাদা হবে, হ্যাঁ, 6, এটা 6 বলছি। The appeal has to be heard out. Stop. Let informal paper books, requisite number of informal paper books be filed by the appellant, incorporating therein all papers that were available before the learned single judge. Stop. Since the respondent is represented through learned counsel, notice of appeal is deemed to be waived. Stop. Paragraph, there will be an unconditional stay of operation of the decree for a period of a fortnight from date. ব্র্যাকেটে দিয়ে দাও ডেটটা, দু সপ্তাহ মানে কবে হচ্ছে সেই ডেটটা দিয়ে দাও। স্টপ। If
6th of August.
6 August, stop. If the appellant secures the decretal amount within that time period to the satisfaction of the learned registrar, original side, the order of stay shall continue till disposal of the appeal, stop. In default, the order of stay shall stand automatically vacated and the decree holder will be at liberty to put the decree in execution, stop. Paragraph GA1 is disposed of.
But since no affidavits are being filed, allegations are.
Since we have not called for affidavits, the allegations in the stay application are deemed not to be admitted by the respondent. Stop. Paragraph, for the sake of convenience, let a copy of the stay petition be included in the paper book.
When will do that?
Paragraph lists the appeal after 3 weeks.
Subject to your lordship's allowing it, I've been able to convince my learned Sherlock friend for another
He
week.
wants 3 weeks,
3
my lord,
weeks.
for
But
security.
2 weeks na kore jeta bolechi, unconditional stay 3 weeks, 3 weeks. But he called you Shylock.
Friend, I said friend.
But I agreed to a 7 days extension, my lord. My lord, in that case, my lord,
Same order.
13th of August, he gets time to put in the
13,
security.
6 August যেটা ব্র্যাকেটে বলেছিলাম, 13 হয়ে যাবে।
And 1 week thereafter, if the appeal comes.
4 weeks.
Very good.
List the appeal 4 weeks since.
Grateful to my learned friend also, without the Sherlock part.
4 weeks since. সেটারও ডেটটা দিয়ে দাও।
One and two.
6 and 7 months.
6 and 7 years.
Item number 8. I am not at 6s and 7s, my lord, but the department is not acting funny, if I may say that. The notice of motion is not being filed. That is the application.
You are the?
I am the applicant in the appeal. But the notice of motion is here. May I file it? But the filing, the application is the notice of motion. The petition has the grounds in support of that. But
Yes.
nowadays, I am told that the department doesn't accept.
Do what?
And only the petition that those grounds are filed and the notice of motion is separate.
Department does not accept the notice
Yes,
of motion.
there was a hugely admonished. The department was hugely admonished also by Honorable Justice Arindam Mukherjee for this reason. That the filing is that notice of motion.
Notice of motion টাই কিন্তু application.
Yes, yes.
পিটিশনটা হচ্ছে যেমন সামন্স যেটা হয়, সামন্সটা অ্যাপ্লিকেশন অ্যাফিডেভিট ইন সাপোর্ট অফ সামন্স টু দ্য গ্রাউন্ডস। সিমিলারলি, কথা বলে জানিও তো কেন নিচ্ছে না। Very well, yes.
Yes, my lord, this is my application in connection with an appeal. Yes. My lord, preferred from 3 applications disposed of in connection with a suit for partition.
My lord, I have a preliminary objection.
Now, why are you not before us, Mr. Bose? Physically?
No, I was unable to come today physically, my lord. I will be there in the next occasion.
What are you asking for today?
I am asking that.
This is
One second, Mr. Bose, 1 second. 1 second, 1 second.
Today I am not pressing anything, but all I seek is, my lord, there are voluminous applications and pleadings in respect of 3 applications which we have not annexed for the convenience of this honorable court and also of my learned friends, my lord. We want to file it by way of a separate informal paper. Kindly grants us 2 weeks time.
What is the prayer in your notice of motion?
My lord, certain injunction prayers which were not granted. My lord, we have also, my lord, there is also a prayer in the nature of, my lord, Order 41, Rule 27, certain documents which we have discovered after, which we have disclosed. But your lordship's practices, it's taken up along with the appeal. So, my lord, as of now, what I am pressing is, my lord, if your lordship kindly passes a direction on us to file informal paper books disclosing all the pleadings.
So that the appeal can be heard out.
So that the appeal can be heard out.
That is fair, Mr. Bose.
And
The
the
appeal
point of
will be
main-
heard
Well,
out.
this is an
Kept open.
appeal from a decree. Kindly have a look at the impugned order. The learned single judge has decreed the partition suit. So they cannot, this cannot be an appeal from order. It is it has to be an appeal from a decree.
And if your lordship kindly takes a look at the impugned order, kindly sees paragraph, my lord, 56. That is the preliminary decree which we got. At
Well, you're
page,
the plaintiff.
I'm for the plaintiff, but we are aggrieved by certain interlocutory applications which were disposed of without granting me injunction.
Disposed of by this order.
By this order, by a common order, 3 injunction applications, 3 interlocutory applications were disposed of, where one of the prayers was preliminary decree. We are not aggrieved by the preliminary decree. Receiver not appointed, injunction not granted in respect of a few, which is the portion of the order which we had assailed.
Mr. Bose, prima
lord.
facie, we see no difficulty, but we will keep that point open.
Well,
We'll leave that point open.
but I'll tell you, lordship, what has happened is he filed 3 applications, interlocutory applications. They were all heard analogous. In one application, he prayed for a preliminary decree. So that part of the preliminary decree has been allowed, against which we are aggrieved also. So we have asked for drawn up certified copy of the decree. We are awaiting the decree. So naturally, now the question is that, my lord, whether he can maintain an appeal from order when a suit has been decreed. A partition suit has been decreed.
Suit has not been disposed of, Mr. Bose. It's only a preliminary decree. Suit is pending.
No, my lord.
And he is not aggrieved with the preliminary decree. He is aggrieved by the refusal of the learned judge to pass injunction order.
Yes, well, prima facie, my lord, I'll show you my respectful submission
We
before
are
your
leaving
lordship
the
is
point
there.
open.
Very
Let us
well,
proceed.
very
We are leaving the point open.
We should come back with the applications on record for your lordship's convenience. Otherwise,
Yes. This appeal is directed against a judgment and order dated April 8, 2025, whereby a learned judge of this court has decreed the appellant's partition has passed a preliminary decree in the partition suit filed by the present appellant. So by the same order, the learned judge refused to pass orders on interlocutory applications made by the appellant / plaintiff. Being agreed by such refusal, the plaintiff has come up by way of this appeal. Paragraph, Mr. Bose, learned senior counsel, representing all the representing the respondent number 5, takes a point of maintainability of the appeal as an appeal from order. He says that it has to be an appeal from decree. We leave this point open, to be decided at the hearing of the appeal. Paragraph, Mr. Gupta, learned counsel, representing the appellant / plaintiff, fairly says that the appeal needs to be heard out. Let requisite number of informal paper books be filed, incorporating therein all papers that were available before the learned single judge. All formalities are dispensed with. Since the how all the respondents are represented.
Appearing for the respondent numbers
2 and 7. These are the contesting respondents.
Yes, and so far as the sisters are concerned,
they are not
they never appeared before the learned single judge.
So all contesting respondents are appearing.
Respondents.
Since all the contesting respondents are being represented by learned counsel, Notice of appeal is deemed to be waived. Paragraph lists the matter. How long you will take?
We are in extreme hurry, my lord. We'll do it within 10 days or a fortnight because we are pressing for certain interim orders because they're
No,
disposing
do
of certain
do
problems.
it within 2 days. We don't mind, will you? Fortnight.
Fortnight.
Within after a fortnight. Stop. GA stands disposed of.
There are certain interim prayers which we are.
Yeah, we'll be hearing the appeal.
Yes, but,
what interim?
but if your lordship kindly keeps, there's a 4127 inbuilt in this GA also. Kindly do not dispose of it.
To that, my lord, let the point of whether he is at all entitled to disclose additional
Yeah, well, I
documents.
would
that
like
point
to
we
use
will-
an affidavit to that
Let the appeal be listed along with the connected application 2 weeks hence.
I'm so grateful.
Wait.
Item number 9.
Yes.
Everyone seems to be here today.
Yes, I am waiting for the respondent number 2.
My lord, I just wanted to tell your lordship one thing. The Supreme Court order should have pointed out. You wanted to know whether it's inclusive of port charges or not. What the direction? I just want to show you that only. My lord, the direction in the Supreme Court, my lord, I'm not placing the order of the High Court. Please come to page 46.
Your somebody was requested to file all the valuation reports.
Yes, it was filed.
You filed.
It was, my lord, from what I have seen personally, and which I believe was the same document which was filed. It appears that 3 valuation reports have been filed and 1 survey report. After the Supreme Court order, there was a direction that you again measure the quantity, and there was some shortfall noted from the 11,000, still within 10,000. I told your lordship, this is what is there on record. Now, 2 of the reports, I believe, are from JB Boda, and the last one is from Alex Stewart. JB Boda has given a price, a particular quoted a price, both before the sale, before Justice Matre, which was set aside by the Supreme Court, and after. Then Alex Stewart quoted a price which is 32. Initially, he quoted 45,000 for metric ton. We said no one will come with 45,000. Now, my lord, as against JB Boda, initially before the Supreme Court, it was about 13,000 or 14,000 metric ton. 13,500 before, inclusive of tax or whatever. So, my lord, that was set aside because one purchaser came and said that, look, I quoted 14,000 odd more without port, without customs, etc., etc. So deduct If you deduct those 5,000, then what the person whose favor it was quoted came down to only 8,000 rupees per metric ton. Therefore, I was much ahead. I was quoting 14,000 plus 5,000, which would have, that is the reason why it was set aside. I just want to show you just two portions of the Supreme Court order only, and thereafter leave it to your lordship what your lordship feels. Now, if your lordship wants to know what you see, coal is a fluctuating thing. This is Ukrainian coal, which is lying. You won't get it now. Nowadays, Ukrainian coal importation has stopped. So if you compare with the price of coal in the market, this is of very high quality, supposedly very high quality coal. So, my lord, it's $1 million question. What would be price? But we have ascertained this time of the year, that is July, the price will be a little low. Price will be a little low, but that's not my headache. It is for the competent people to decide what the price would be. They will do the valuation as it fell from Justice Rai. It will do valuation. Correct. That's the order. You have to comply. Now, my lord, two things I want to show you from the Supreme Court order, because one question arose about customs or port, etc. I just want to show you that. Well, the petition, just page 46. This was December 2017, my lord.
Yes.
My lord, Supreme Court is saying, maybe some confusion is created by the public notice that was published by inviting bids, as it does not categorically state as to whether reserve price of 13,000 was exclusive or inclusive of the taxes. Fact remains that when, as per, have you got the, fact remains that when as per the reserve is fixed without taxes, offer of 14,000 per metric ton after excluding taxes would be well below 13,000 per metric ton. Calculation given by the appellant, that's LMJ, which is not refuted by defendant, that is the highest purchaser. My lord, may please see the table, and you will find, my lord, there is mention, my lord, of right in column C, my lord, at that point of time in 2017, port charges was approximately 2,000 into 10,000 will take you, my lord, to about 2 crores. My lord, have you seen that, my lord? And the total came to 5,104 per metric ton. And my lord, the Supreme Court, my lord, have I? Yeah, sure. Then the Supreme Court said actually what you are bidding is only 8,895. Next page. Therefore, it would be impossible to accept offer of which turned out to be a sum of rupees such and such. Now, my lord, kindly see para 15. Therefore, we therefore allow the appeal, set aside the order, is directed to get fresh valuation so that present day valuation ascertain basic or public notice in question be issued with a clear stipulation now that the reserve price is exclusive of taxes, and if it is possible to ascertain the exact amount of charges and taxes which may also be indicated. So when a purchaser, my lord, is bidding and he is quoting, my lord, a particular price, he may bid, and the valuer should also indicate that this is the approximate price. No one can judge what is the customs and side. Now, the bills which I have from the port, my lord, and this is something which the client, I have not verified. My lord, last time it was said of the side till 24, it was 7 crore. No, some of the charges, like insurance, I've deducted. Whether you can't claim, that's not the Supreme Court order. It's just both charges. So that's what they say, my lord, that, my lord, as up till date, on account of port, charges, rentals, and wharfage, which is also as per the bills, it will be approximately 6 crore, my lord, 10 to 20 lakhs, 6.2 crores.
Where do we get that?
My lord, there is a, my
Oral
lord,
submission made by you.
yes, yes, of course, my lord, from time to time that is being happening, that you furnish the statement, then aside. So, my lord, this is an approximate
Can you
indication.
give us in writing, approximate, be it so?
Yes, of course.
Can you give us in writing?
Yes, yes.
Just
My lord, I can give you, but authenticity, I personally, my lord, haven't checked. So you will be relying on my statement that these are, you know, it's a matter of calculation.
let your client ascertain from the port trust.
Yeah, no, they have paid the bills they have, but they are not on record. That is what is going on for the last few years. Everything is going on. It was 2 crores definitely. They accepted.
Lastly, can you hear me for 2 minutes only? After Mr. Bose completes.
My lord, we can only indicate approximate, right?
Lordship, only give me 2 minutes. My lord, kindly see.
You are LMJ.
LMJ. My lord, the order which my learned senior friend is placing was obtained at my instance. I went to the Supreme Court to set aside the sale which was conducted at a original low price of 8,000. I got the earlier sale set aside. Now kindly see page number 40.
How are you interested? You are.
I have been declared by the arbitrator as the owner of the goods.
I
in
see.
an award.
I see.
And where Mr. Bose's client is the award debtor, he has filed an application for setting aside of the award. Arbitrator has said that he has to pay me 18 crores as the value of the goods because Mr. Bose's client could not deliver the goods to me. So he has to pay the price of the goods.
Anyway.
Now, 2 things, my lord. Kindly see page 47, the order which my learned friend was placing, para 15. Kindly see the para 15 of page 47. We therefore allow this appeal and set aside so that the present day valuation of the goods is ascertained. So my endeavor and my humble submission before this court is, my lord, this last valuation report is of March 2024. Now we are in July 2020.
Have you read our last order?
No, that's what just.
That's exactly what we are trying to.
You are not.
No, I was not there on the.
But then you should have taken instruction, Mr. Sharma.
Secondly, my lord, only one more submission.
Tell us, through whom should we get the valuation done this time? There's J.S. Boda, there's Alex Stewart. No. We'll do it. We are taking charge. It's 8 years have gone by, Mr. Sharma.
One more thing, just one submission.
Yes.
Before I finish, only one submission. Lordship, see this order.
My lord,
My lord, this order is passed in 2020.
Keep the
Order of this court, my lord, order dated the 21st January 2020. My lord, this appeal is already disposed of. Mr. Bose's client has taken on this application in the appeal which is not pending. Now, my lord, see who is the appellant. Today, there is no existence of the appellant. And this order, my lord, they were asked to take steps to amend the cross title. Today, the appellant is under liquidation, represented by the liquidator. And my lord, today, practically speaking, my lord, no steps have been taken after 2020 to even make it regularized. Today, my lord, there is no appellant.
May I answer this
question? For 5 years, Mr. Upadhyay is appearing. But my lord, kindly see the cost title of this application in which several orders have been passed by this court, and kindly see the first name, Dhankuni Steel. There is no existence of Dhankuni Steel, the appellant.
May I answer that, my lord, also? First
But
about.
it is not for Mr. Bose to answer. It is for the liquidator to take steps. Kindly see the order.
Who has appointed him also, I don't know, but he is appearing.
Who is appointed? That
Yes.
order. Today, the liquidator appointed by the National Computer Tribunal. Who has appointed is not relevant.
We filed an application, Your Lordship, to liquidator to be substituted, Your Lordship. It was contested by them, by the LNG, Your Lordship, who is there presently the respondent to whom the Mr. Sharma is representing, Your Lordship. So, in that appeal, Your Lordship, before the learned single bench, Your Lordship, it was allowed. Application. We amended. Suit is already amended. They filed an appeal, Your Lordship, against that, which is pending before the Honorable Division, before the Honorable Chief Justice. It is assigned to him, Your Lordship. That application is still pending, Lordship, what he's saying at presently. We have taken steps that is pending because the appeal is pending. We are not able to amend the cost title of the appeal, Lordship.
We have said that is a different thing. We have said
Mr. Sharma, please keep that point aside for the time being. Do something.
I'm not stopping in the way of the sale. I'm only endeavor is, my lord, that as the lordship earlier order indicates a fresh valuation.
Yes.
Correct.
Question is through whom? That first, Mr. Bose.
Do you want to know about the 10,000 which he said arbitrated and all?
No. We want you to file a 2-page whatever, bringing on record the port charges.
Well, I can file it right now.
File
He has given, but I, as a counsel, my lord, this is something which the clients have said, and I have immediately rejected. Immediately.
Would your client be in a position to file a 2-page affidavit annexing this document?
Yes, about the about the port charges.
Yes.
My lord, he of course included many items which, like for example, he has paid to port about tarpaulin. It's open to cover. I said that doesn't fall within port charges, so I said cancel. So these things, after giving this, you see, it's verification of the bills. I haven't. So I can only indicate to you right now, as per the statement, it is approximately what on the basis of it's about
Mr.
620.
Bose, we want an affidavit from your client. File it. It goes by Monday. Just a 1-page affidavit.
Lordship, before the Lordship directs one thing, I would like to indicate one thing. Lordship will come to page 3 of the application, Lordship. Lordship will see the prayer of the suit, Lordship. The suit was for the specific delivery of the 11,000 074.90 metric ton coke to be delivered, Lordship. This was the total quantity, Lordship. This was the total quantity for which we both of us were fighting.
They are fighting.
This is the goods which were supposed to be in his custody, Lordship. Lordship will see the order annexed by Mr. Bose's client. That is as page 29, Lordship.
That's what I wanted to show you, Lordship, that about the 10,000. They are both fighting. Yes, please.
Lordship, this was the order which was challenged before the Honorable Supreme Court, Lordship, where the sale was confirmed. Lordship, at page. Lordship, at page 32, Lordship will see the last para. The sale of 10,000 metric ton coke to Tycon Supplies Limited, such and such, being the highest bidder, was confirmed, Your Lordship. Tycon shall deposit the balance amount of their other price where within 7 days offer price, remove 10,000 metric ton within 15 days from the date of the full payment of the amount. Now the second paragraph, Your Lordship will see this. The respondent shall provide the detail of the statutory dues, taxes and other charges paid from time to time to the value to the special officer within a week from the date. The balance quantity, that is the 1,465.9 metric ton coke, shall be delivered to the appellant. That is to me, Your Lordship. Now they are saying, Your Lordship, there is a shortage in this 1,465 metric ton. If the shortage is of around 800 plus metric ton, which goes to around 3 crore 75, if we take it as a value of
Mr. Upadhyay, at this moment we are not concerned with this.
Because, Your Lordship, because if a Lordship directs to sell the 1,000 metric tons, I am supposed
10,000
metric tons, then I'm supposed to receive this amount, this metric ton, which is not there. They have to give an explanation to that, what happened to that amount, because, Your Lordship, 3 crore 75 lakhs, that amount was 3 crore 75 lakhs. The valuer is saying that it is lesser than what it was before.
Not valuer, surveyor. Again appointed.
120 of the report filed by the learned special officer.
What is it? Tell us.
The special officer had asked Mr. Bose's client, this is the last minute which has been annexed. So Mr. Bose's client is going to file an affidavit. He can comply with this order also. The special officer directed Mr. Bose's client to provide the statement of bill of entry, the custom duty which was paid for 10,000 metric ton of coke to be sold out of the total stock of 10,613 MT lying at the godown, so that the public notice and the terms condition of the sale can be finalized, because the order of the Honorable Apex Court is that exact amount has to be given in the
Why
draft
don't you
notice.
furnish these particulars also, Mr. Bose?
I will file bill of entry when it's not duty paid goods. Miller, what is he asking? We have replied to this letter. Only 6,000.
There is no minute after that. I don't know what reply.
No, because not holding.
No excitement helps.
Now, my lord, we have replied to this.
Annex that reply to the affidavit.
Very well.
Annex that.
Very well, my lord, I will annex.
Issue.
The shortage that Your Lordship will record.
We will record nothing, no.
Because Your Lordship will be suffering of 4 crores around the loss.
File an application. Mr. Tilok Bose's client shall file an affidavit.
My lord, it's Sharat, client's name is Sharat Chatterjee and Company.
Very well. Mr. Bose's client, namely Sharat Chatterjee and Company, bracket A, VSP, bracket closed, private limited, shall file an affidavit disclosing the amount of port charges that are due as of date, disclosing the approximate amount. Stop. Paragraph. Mr. Sharma, learned senior counsel representing
Respondent number 2.
the respondent number 2, bracket the LNJ.
No, now in it is what?
Okay. Sri Muni Subratro International. Now the name
Muni
is changed,
Subratro.
but that has not been recorded in the cost statement.
Respondent number 2. Respondent number 2 says that learned special officer had called for certain data / information from Mr. Bose's client. Stop. Mr. Bose, learned senior counsel, says that the special officer's letter was duly replied to by
letter dated 1st March 2025 with copies to all of them.
By his client by a letter dated March 1, 2025. Stop. Let such letter be also filed along with the affidavit. Paragraph. List the matter once again. Monday?
Whenever it's convenient.
So after Tuesday.
Then Wednesday.
Oh, sorry.
Wednesday date দিয়ে দাও।
এই বসে পড়েছে।
Number 10.
Ashima, I'm appearing for the appellant. The respondent number 1 has indicated, the heirs of respondent number 1 has indicated that certain respondents had expired in the meantime during the pendency of the appeal. May I come back with an application for substitution?
6 steps.
I am applying for some of the respondents.
Lordship, some
Learned advocate for the appellant says that her client has been informed by some of the respondents, informed by the heirs.
Heirs of respondent number 1.
Heirs of the respondent number 1, that some of the respondents have passed away during the pendency of this appeal. Stop. She requests that the matter be adjourned for 2 weeks.
Yes, Lordship, Lordship may record that respondent number 1, respondent number 3, 4 and 10 have expired.
Some of the respondents being respondent numbers 1.
This is pursuant to orders.
1,
3, 4 and 10.
4 and 10 have expired.
Lordship, this was pursuant to order of
the pendency.
it was pursuant to order of your Lordship's 9th July 2025.
Unnecessary. 2 weeks, so that the appellant may take appropriate steps in the matter. Paragraph. List this matter once again on date ta diye dao. Stop. If in the meantime the appellant files any application, the same shall be served on So same shall be listed along with the appeal on the adjourned date.
I'm great.
Thank you.
Item number 11 and 12.
Eleven is my appeal. 12, I'm respondent 12. May I, my lord, this is one indulgence. Mr. Ghosh is leading me. Mr. Dhruva Ghosh.
One Mr. Ghosh is right next to you.
Sorry,
So unless
Mr.
you give us the full name.
Mr. Dhruva Ghosh is leading me. Would it be Lordship's pleasure to keep it Friday or any other day?
Please ascertain the pleasure of your learned friend.
Friday, next week. Any. Next week.
It's only this, my lord. I appear on behalf of the depositors.
Very short. I have, if somebody is in difficulty, my lord, I am not standing in the way. I'll tell you, lordship, my lord, it relates to, my lord, the estate or, my lord,
You are for Oshim.
No, my lord.
No.
Oshim is one of the depositors for whom I am appearing.
movement traders, my lord, the appellant in the second matter.
I see.
Now, my lord, the properties of, my lord, this Chatterjee Pope group, my lord, including, my lord, belonging to Hilgers, my lord, those were, my lord, taken custody of by this honorable court through special officers.
This is Chatterjee International.
Yes.
Yes.
For paying off the creditors. These special officers were directed, my lord, to sell properties. Now, the sale took place in respect of this property, which is Dhanbad. The Dhanbad property, my lord, by advertisement. My client, obviously, by proper auction. Now, my client was the, my lord, purchaser. Documents were executed. Then, my lord, special officer went there and, my lord, gave possession to my
So this was a court sale.
Yes.
Joint administrators.
Oh, yes. Joint administrator. Not special officer, joint administrator. Now, then, my lord, my learned friend's client came up with an application saying that they had purchased the property. Yes. They had purchased the property from Hilgers or, my lord, somebody connected with Hilgers. And, my lord, that is why it could not have been sold. The property could not have been sold by the joint administrators. We pointed out that, my lord, the alleged sale in favor of my learned friend's client took place when the order of injunction was there. The property could not have been sold. In any event, there are other points, my lord, which I shall point out, my lord. Today, my difficulty is, my lord, they are in a happy position. I have, my lord, invested the money and I really do not know my fate.
Day after tomorrow?
My lord, maybe on Monday, my lord. On Friday, I have.
You are for whom?
I'm for the depositors, my lord. I am the most prejudiced group because the fight is going on between these two applicants. My lord,
depositors?
Yes, my lord, the depositors of Chatterjee Pope, who is to get the money from the sale of these properties. There are the orders, my lord, that if
you are
the
party?
Yes, my lord, I'm very much a party. I'm the plaintiff in the suit.
You are the
Yes.
plaintiff.
Yes, man, it's my suit.
I have to know for the legal heirs of Mr. Vinod Chatterjee. Not if a copy, not I believe we were somewhere, but we can't find the copy. Not if a copy could be given to us on usual terms of the appeals, both the appeals.
Give Mr. Dashgupta, give him copies. When, Mr. Mitru, tell us?
Friday, your lordship.
Friday? Oh, Mr. Ghosh is saying
Yes,
something
some
else.
difficulty, my lord. There's a personal.
Jornindu Ghosh.
Maybe on Monday, my lord, if it is not inconvenient.
Dakho bhai. Monday is, I think, lordship takes commercial.
Monday commercial will be first, so non-commercial is very uncertain.
Then, my lord,
Then again, it will be Wednesday.
Wednesday, my lord.
Not Wednesday. Let it be Monday because Tuesday appellate side normally gets exhausted.
Tuesday it will be taken up. I'm sure it will be taken.
So let it run in the list.
I'm deeply obliged, my lord. There's some difficulty on Friday.
Mr.
The facts, my lord, I don't think that we shall take long.
Mr. S.N. Mitro, learned senior counsel, representing the appellant in APO 486 of 2015, gives us a brief outline of the facts of this case. Stop. Paragraph. Mr. Dashgupta, learned advocate appearing for the appellants in APO 489 of 2015 seeks accommodation, stop, paragraph, on the request of Mr. Shornindu Ghosh, learned senior counsel representing
plaintiffs, my lord, the
respondents
group.
oblique plaintiffs. Let this matter be listed again on Monday, right?
I'm deeply obliged.
Fairly long order. এই একসঙ্গে হবে combine.
I'm deeply obliged, my lord.
My appeal.
Mr.
Pranajit Chaudhary,
Well, this was a disclaimer application. Under 535, I am an agreement for sale holder. Agreement for sale executed more than a year prior to the commencement of winding up. When I filed the application for disclaimer, the learned company court has rejected my application of disclaimer primarily on the ground that the agreement for sale of a immovable property there was time was of essence, and the property I could not have filed an application for a suit for specific performance, and therefore my application fails. That is the primary ground. My lord, if your lordship looks at the grounds which could have been taken are under 531 and 531A of the old act, which was fraudulent preference and avoidance of the transaction, my lord. My lord, if I just take your lordship through some of the important dates and, my lord, what has transpired, and then, my lord, I can take your lordship through the provisions of the act, my lord, the old. I've got the old act with me in case, my lord, your lordship doesn't have. This is the old 56 act. I have got two of the old acts, in case your lordship wants. Most of the new bear acts don't have the old act in it, my lord.
No. 56 act.
56 act.
I have কোটে রেখে দেবে একটা
I've got them, my
দুটো
lord.
Yes. Yes, just
I'll go through the facts, my lord.
Yes, allow us to go through the judgment.
Yes, my lord. 1st April 1995 is an agreement for sale by which I have agreed to purchase a property of this. Oh, your lordship is going through the order judgment. My lord, the judgment is page 262.
The winding up petition was filed on 15th March 1996, and this agreement of sale agreement was executed on 1st April 1995. That is within a year.
I will point out everything, my lord.
Okay. Seven, 97. Simple. Very open-ended, particular time. Simple. Time starts. Yes, Mr. Vilkji.
Well, primarily from the order, your lordship will find that lordship found that the agreement agreement for sale. One is she says that it has been modified.
Just a few
Yes, my
preliminary queries.
Yes, my lord.
The factory was never made operational by you.
Factory was not
Never.
made operational.
What is the quantum of land?
It's, my lord, 32,389 square meter.
Square meter.
That is
1 square meter is roughly 10 square feet.
10
roughly.
square feet. So 3 lakh square feet then. Approximately 3 lakh square feet. It's a big property, my lord. There was factory shed. There is some small
3 lakh. 30 lakh. Oh no, 3 lakh. 3 lakh.
32,000.
3 lakh.
So 3
3
lakh
lakh.
10.
Where is this?
Mysore. In Mysore.
I'm not acquainted with Mysore.
I also, my lord.
What's the key?
I'm from the doc. Well, from what I find, my lord, there's no dispute with regard to any undervaluation of the property in the agreement for sale. Only issue raised by the official liquidator was whether it's a fraudulent preference or not.
What do you say to limitation?
Well, limitation of the time was not of the essence, my lord. If your lordship sees the agreement for sale also, there was a time prescribed which may be extended from time to time. Your lordship, I'll show the clause. And my lord, there is judgments of Supreme Court. It's a settled law, my lord. Even if there's a stipulated time within which it has to be performed, still the clauses have to be seen to see whether time was made of the essence or not. Just because there's a stipulation doesn't mean the time is of the essence. And recent judgments of Supreme Court also go on that same line. Limitation, my lord, I don't think, my lord, I think I have a point there, my lord. I can show the judgments also on that point. And even the clause which is there, the clause itself says, my lord, by 31st March 1998, or as may be extended from time to time.
No, let us say the parties by agreement give a go-by to that stipulation of 31st December 1998.
Yes, my lord. Yes, my lord.
It becomes open-ended.
Yes, my lord.
There is no time period.
Yes, my lord.
Then, according to the learned judge, your limitation period will start running from the date when the OL refused to perform.
OL has never refused.
Not responded to your letter of 2001, whereby you called upon the OL to execute the deed of conveyance in your favor. This is refusal, according to the learned judge. This is refusal. You should have filed the whatever application or suit within 3 years from 2001.
Well, I will show from the documents. In fact, there is a letter by the OL where the OL says, give me more documents to show what is your right.
That's 2013.
2013, my lord.
That the OL says by mistake.
My lord, your lordship has to see the facts altogether, my lord.
Yes,
The
no,
OL
if it is-
itself has,
Yes.
OL can't, my lord, just because he's written a letter, he can't say I've made a mistake. At no point of time has OL, my lord, filed any application to say, my lord, that this property should be taken possession of. They never sought it out.
Argue your
I will,
case.
I will.
Argue your case.
Well, let me go through the facts, and I'll also go through the two important sections, 531 and 531A. My lord, let me take your lordship through the sections first, my lord. 531, if your lordship takes, these are the two provisions under which, my lord, the property can be held to be, the transaction can be held to be voidable or void. And 536 also, but 536 will not be applicable here because that's prior to. If your lordship will take the provision. 531. Any transfer of property, movable or immovable, delivery of goods, payment, execution or other act relating to property made, taken or done by or against any company. Well, next is very important. Within 6 months before commencement of its winding up, which had it been made, taken or done by or against an individual within 3 months, that's for insolvency, before the presentation of an insolvency petition on which he is adjusted, would be deemed in his insolvency a fraudulent preference, and shall, in the event of a company be wound up, be deemed a fraudulent preference of its creditors and be invalid accordingly. So, my lord, two important things. One is, my lord, it's a creditor's action. A preference of one creditor over another creditor, and a transaction which has taken place 6 months before commencement of the winding up. That's 531. If your lordship
Winding up was on.
My lord, winding up application here was filed on 15th March 1996
by some creditor.
And winding up was passed in order of winding up is 1999. But the commencement 6 December. My lord, under section 441 of the Companies Act, my lord, commencement of winding up is the date on which the winding up application has been filed. So if you take the date on which the winding up application has been filed, 15th March 1996, your lordship can travel, for 531 to be applicable, 6 months is the period. So the agreement for sale of the disclaimer applicant is 1st April 1995. That's more than 6 months. So 531 on the face of it is not applicable. That's the first point.
Petition presented.
Company petition was presented on 15th March 1996. It's CP 116 of 1996. It was presented on 15th March 1996. No dispute over
Winding up order 6 December.
6 December 1999.
Section 441 relates back.
Relates back to the date of filing of the petition.
Agreement date is 9th April.
1st April 1995. Well, after the agreement for sale, there has also been an agreement for lease, but I'm not relying on those. And it cannot be said that the agreement for sale has been modified by an agreement for lease, my lord. Those are two separate transactions altogether.
So 531 doesn't apply.
Yes, my lord. 531 doesn't apply. Now, my lord, the next clause which applies, the next section, which could have been taken help of, is 531A.
Yes.
Any transfer of property, movable or immovable, or any delivery of goods made by a company, not being a transfer or delivery made in ordinary course of its business, or in favor of a purchaser, encumbrancer, in good faith, and for valuable consideration, if made within a period of 1 year before presentation of the petition of winding up by the tribunal, or by passing of resolution for voluntary winding up of the company, shall be void against the liquidator. So, my lord, so far as the liquidator is concerned, it is only 531A which can be applicable, because 531A is with regard to the liquidator also. 531 could not have been applicable at all, because that's only one creditor over another creditor and 6-month period. 531A is against the liquidator, void, and it's a period of 1 year. I come within that 1 year period, but for that, the official liquidator had to show that this transaction.
This is 1 year backwards.
1 year backwards. Before. 1 year before. The language used in both 531 and 531A.
Not within.
Made within a period of 1 year before the presentation. So the language used it's that way, my lord. Within a period of 1 year before. So from if we take, my lord, the date of filing of the winding up, 15th March 1996 and 1 year, then my transaction comes within that 1 year period. For that, the official liquidator had to do two things. One, it had to file an application itself, saying that the transaction is void under 531A. That's never been done. Two, even in defense, when I filed an application for disclaimer, ought to have taken a point that it's void under 531A with pleadings that the transaction was not in good faith and not for valuable consideration.
Yes.
The pleadings of the official liquidator, I will show those, my lord, also. In the disclaimer application, the opposition to the disclaimer application completely goes on 531, that it's a fraudulent preference. There is no averment also that the transaction was not in good faith or that it is not for valuable consideration. In fact, it is no one's case that the transaction was not for valuable consideration. In fact, my lord, your lordship will see, my lord, from the order impugned also, there were two valuations made prior to purchase of the property, and the value at which the property has been bought is at par with the valuation report. So 531A also, my lord, in my respectful submission, is not attracted.
Has not been invoked,
has not been invoked and could not have been attracted also.
Why could not have been attracted?
Well, rather has not been attracted.
Yes.
Has not been attracted. And could not have been attracted because there is no case of undervaluation. For undervaluation, my lord, proof had to be shown that there has been undervaluation. I'll come back. Your lordship will come back. Now, my lord, Supreme Court under the previous insolvency regulation and subsequently under the Companies Act also, my lord, it's been held that when a provision like 531A, where avoidance of voluntary transfer is taken, where the issue of good faith and valuable consideration is there, and it's void against the official liquidator, has held, my lord, that under the insolvency regulation, official assignee, and now under the Companies Act, the official liquidator, it is the burden or the onus on the official liquidator to prove that the transaction was not in good faith and, my lord, not for valuable consideration. That's also not been discharged in this matter at all. So, my lord, under both the provisions, it could not have come, my lord, to avoid the transfer. Going, my lord, strictly by 531 and 531A, 531 not applicable at all, and 531A, my lord, the onus which was there, my lord, the burden of proof, that has not been discharged by the official liquidator, and more importantly, that's not the official liquidator's case at all. Now, only provision, my lord, which the learned court has, my lord, court below, my lord, has relied on, the company court, is 536. That is for transactions post winding up. My lord, let me just read it, my lord. 536. In case of voluntary winding up, any transfer of shares in a company not being a transfer made or with the sanction of the liquidator, any alteration in the status of the members of the company made after commencement shall be void. My lord, 2 is which is applicable. In the case of a winding up, any disposition of property of the company and any transfer of shares in the company or alteration in the status of members made after the commencement of the winding up shall, unless the tribunal otherwise orders, be void. In this case, my lord, so far as the lease agreement is concerned, that at the highest can be said to be void. It could have been, my lord, learned court could have held that, though, that's also not void if that was the case. But so far as the agreement for sale is concerned, that could not have been held to be void under 536.
Why your agreement was 9th of April, 1st of April
95.
Petition was
15th March 96. Post commencement of winding
96.
Post 96. Post commencement of winding up, well, that's after 15th March 96. If there is a transaction, that could have been held to be void under 536. So these are this is the scheme of the act and the provisions which are applicable. And my application is under 535, where I am seeking disclaimer.
Yes.
Now, the facts, how it transpired, I admittedly was a creditor of the company. Around 8 odd lakhs was due and payable by the company to me prior to my agreement for sale. 1995, 1st April 1995, there's an agreement. Before that, 18th March 95, there's a board, there's a resolution of the board of directors of the company agreeing to sell the property. And finally, 1st April 95, there's an agreement by which the property is agreed to be sold for 1.70 crores. That 8 lakhs is to be adjusted and balance money is to be paid in installments. Till so far, 1 crore 39 lakhs had been paid and 31 lakhs was due and payable. This is the monetary aspect of it. In between, 1996 is the application, is the winding up application. Winding up order is passed only in May 1999. In between, what happens is,
May 99 or December 99?
May 1999. So it's sorry, December 1999. My bad. 6th December 99. 19th, there's a confusion, your lordship will find. 19th May 99, there was an order in terms of prayer A, which is the winding up order. But there was a default clause that order in terms of prayer A unless money is paid. Like, if your lordship, the orders which were passed, that money was not paid, so automatically prayer A ought to have come into effect, but that did not come into effect. So in December 99, the court which passed the winding up order, in fact, took note of that and said that although it has come into effect, but I'm still passing an order of winding up. So December 99 is the order of winding up. In between that, my lord, when the despite making payment of a substantial sum, my lord, when the conveyance could not be executed, so the parties, the company and the applicant, well, they came into an understanding that let me run the company, let me run the factory. You're not running the factory, let me run the factory. So you lease out the property to me, and I will take the company, I will run the company, run the factory in the meantime. And when you've dealt with all other creditors and you've dealt with all cases, then at that point of time, the agreement for sale will be executed. And the money which is being paid as premium for agreement for lease, that will be adjusted against the agreement for sale. That was a transaction in May 1999. Sorry, in February, 10th February 1999. That's also on record. Furtherance of that MOU of February 1999, on 25th March 1999, there was also a lease agreement which was executed, and possession of this land was given to me. So from around March 1999, possession of the property has been with me, and I have paid around 1 crore 39 lakhs altogether.
Today also possession is with you.
Well, there is your lordship, subsequent to filing of the winding up petition. In fact, in the last 2 years, there have been some orders where there is a dispute as to who is in possession. In fact, my lord, in contravention of an order of division bench, my lord, an application was also filed by which, my lord, they sought to take possession, but our case is we are in possession. Official liquidator still says they are in possession. In fact, that is an issue which is left open by the learned single judge. Order passed in May 99, but that's not before your lordship today. There's a second appeal which considers that issue. That's also before your lordship. I'll check, my lord. There's a second appeal, but today we are only concerned with the disclaimer, my lord. Official liquidator, so my lord, after the winding up order is passed in December 1999, and we come to know of it, we write to the official liquidator immediately. Our letters written to the official liquidator is in 2002. We write 2001. January 2001, when we come to know of the winding up order, we write to the official liquidator saying we are in possession of the property, we are an agreement for sale holder, we are in the process.
Where is that?
The letter is at page 77. My lord, page 80. Page 77 is the winding up order. Paper booking. Page 80. We understand by virtue of orders of May 19th May 99 and 6th December 1999, both passed by the Honorable High Court, the above company, Messrs. Remington Rand India Limited, was directed to be wound up. This is to inform you that company, Messrs. Remington Rand India, now in liquidation, has been the owner of land and factory for manufacture of electrical push-button telephones and applied products situated at number 85A, Hutagali Industrial Area, Hutagali, Mysore. The company have incurred huge losses and closed down the said factory, and further decided to sell the factory as a going concern, and the same on as is where is and whatever there is basis in favor of some intending buyers. In view of the above, please note that by an agreement dated 1st April 1995, we had agreed to purchase the above land and the factory as a going concern for a total consideration of 1 crore 70 lakhs only, to be paid by us in a phased manner as stated. The company had agreed to complete the sale by 31st March 1998, and that in the event of delay and default on part of the company to complete the sale, we would be handed over possession of the said factory as a going concern, and on the same, a lease basis with right to run and carry on manufacturing thereat at the lease pending completion of the sale by the company. The said agreement was entered in pursuance to a resolution of the Board of Directors dated 18th March 1995. Please note that we have duly paid an aggregate sum of rupees 1.18 crores towards part payment of the agreed consideration during the period up to 16th September 1998, and we were also ready and willing to pay the balance amount of the agreed consideration. The company failed to complete the sale and further perform its obligations under the above agreement for sale. In view of this, after long negotiations in the matter, MOU dated 10th February 1999 was entered into between ourselves and the company, recording mutual extension of time to complete the sale of the above factory premises by the company. And pending completion of sale, the company agreed to enter into a lease agreement permitting us to carry on manufacturing of the products at the said factory, subject to necessary approval of the board of directors. Subsequently, the Board of Directors, by its resolution dated 18th March 1999, duly ratified the MOU dated 10th February 1999 and also approved the making over of possession of the factory on lease basis in our favor as per MOU. In pursuance of the said MOU of 10th February 1999, please note that by an agreement for lease dated 25th March 1999, the company had duly granted lease as also made over possession of the factory premises in our favor, with liberty to us to run the factory and carry out the manufacturing thereat at our own risk and cost. Thereafter, since after the said agreement of 25th March 1999, we paid a further sum of 21 lakhs to the company and the same adjusted toward consideration of the purchase. We are sorry that although we had duly paid an aggregate sum of 1.39 crores only towards part payment of the agreed consideration, as also duly forwarded the company a draft conveyance deed in respect of the above factory, and were further ready and willing to pay to the company the balance consideration amount of 31 lakhs only, the company failed and or neglected to complete the sale as per the above agreement. It is regretted that despite our having possession, as also having entered into necessary settlement agreement with workers, and also obtaining all registrations, permissions, clearances from different authorities, we could not commence and carry on manufacturing process at the said factory because of the default on part of the company to execute and register the proposed deed of conveyance. Pending the completion of sale and execution of the registration of the formal deed of conveyance in our favor, we find that the company has been directed to be wound up. In the premises aforesaid, we call upon the official liquidator of the company to complete the sale and or transfer in respect of the above factory in our favor by executing and or registering formal deed of conveyance on our paying to you the balance amount of the agreed consideration being 31 lakhs. We also enclose herewith copies of the agreement of the sale dated 1st April 95, MOU dated 10th February 99, and agreement dated 25th March 99 for your ready reference. So from after this letter of 2001, we have written to my lord the official liquidator on 3 further occasions. 7th July 2005, that's at page 83, 9th April 2009 at page 84, and 27th June 2011 at page 85. There has been no response. Official liquidator had been quiet. They never said no. Then, my lord, 5th August 2011. This is that contentious letter, my lord. If your lordship sees, page 87. With reference to your above referred letter, it appears that various correspondence were taken place in respect of the subject property since winding up order of the company of 6 December 99. Hence, it is requested before your good self to provide following informations so as to proceed with the subject property in accordance with law. They demand copies of those same agreements which we had already given to them before. My lord, copy of agreement of 1st April 95, copy of MOU of 10th December 1999, and lease agreement of 25th March 99, and copy of relevant certificates. You are requested to submit the above documents at the earliest to enable this office to examine and proceed further in this matter. So there is no refusal.
An acknowledgement, Mr. Mukherjee, an acknowledgement, assuming this to be an acknowledgement, after the limitation has set in, it will extend limitation.
Well, limitation has not set in. It has to be a refusal. Immovable property, there has to be a refusal. There can't be, if negotiations are going on or there has been silence, that is not refusal so far as time is of essence for seeking specific performance.
Anyway,
next, we again write to the official liquidator. There are 2 more letters, but official liquidator finally replies. Again, 21st June 2013, page 90. This is the letter, my lord, my mistake. This is the letter which the official liquidator has said is a mistake, not the 2011 letter. June 2013, page 90. With reference to the above, the undersigned is directed to state that since the property under consideration is not under possession of this office, and as per admission of the fact that the same is under your possession since long back, even without paying, it should be paying, not praying, paying the full consideration, you are requested to take out proper and appropriate application before the Honorable Court paying necessary direction in this regard. And that's what we've done. So, my lord, that refusal to perform had never come at any point of time, 2011 or 2013. Immediately after this letter came, my lord, of 21st June 2013, we filed a disclaimer application, which is CA 570 of 2013.
Which is that page?
My lord, that was filed, my lord, page 4, first annexure. That was filed in December 2013, 13th December 2013.
And the AO is at page?
AO is very important. Your lordship will take page 91. There are two aspects of the AO which are very important. Well, there's another aspect which I should also point out. But I am also the secured creditor in regard to this property, and the property is mortgaged to me only. That's also, it's a relevant fact which ought to have been taken note of. I am the secured creditor and the property has been mortgaged to me. My lord,
by deposit of title deed.
By deposit of title deed. By assignment. My lord, what had happened, my lord, one moment. Sorry, my lord, 1989, much prior to all these transactions, the company had taken a loan from ICICI Bank and had mortgaged the property. ICICI Bank was a secured creditor and had the title deeds of this property. Subsequently, my lord, this loan of ICICI Bank was assigned to Kotak Bank, and Kotak Bank has since assigned it to me by registered deed of assignments. And official liquidator has acknowledged that ICICI is a secured creditor. They don't acknowledge me as a secured creditor because although I am the assignee thereof. There were proceedings before the DRT. Again, ICICI had instituted against this company, and it was during the period of the proceedings were pending before the DRT that ICICI assigned to Kotak. Kotak has since assigned to me. Now, if your lordship takes the AO of the official liquidator, starting at page 91. My lord, paragraph 5, your lordship, the official.
Yes.
Well, at paragraph 5, your lordship will find it is admitted here that the official liquidator could never take possession of this property. Paragraph 5. In the circumstances, possession of the property of the said company and particularly possession of the very valuable property at 85 Hutaguli, Mysore could not be taken. Erstwhile directors have not made over most statutory records. Paragraph 7, essential. There are following secured creditors of the said company. Number 1 is Industrial Credit and Investment Corporation of India. That's ICICI. It's my lord, ICICI's loan which has been assigned to me. My lord, paragraph 10, if your lordship takes. The applicant thereafter issued several letters requesting execution and registration of deed of conveyances in respect of Mysore properties. Copies of letters dated 31st January 2001, 7 July 95, 9th 2005, 9th April 2009 and 27 June 2011 are annexed. They don't say refusal. The official liquidator subsequently requested for copy of documents in support of contentions of the applicant, whereupon by a letter dated 17th August 2011, the applicant submitted certain documents. Copy of the letter is annexed. None of the documents referred to in the application or in the letter dated 17th August 2011 are adequately stamped, registered, though required to be compulsory stamped and registered. The said documents are required to be impounded and cannot be looked into. In any event, the said documents cannot be relied upon. Para 13. Without prejudice to the aforesaid, I say that the said documents are completely suspicious, suspect, and the transactions recorded in these documents are equally suspicious. There is no reflection of any of these documents or transactions contained in the books or records of the company. On the other hand, this property was mortgaged in favor of a secured creditor, and necessary reflection thereof is found in the records of the official liquidator. So they accept the secured creditor part. Now, paragraph 15. Para 14. Amongst the documents which have been concealed by the directors are minutes of board meeting of the company and other relevant records from which authenticity of the transaction could not be ascertained. In any event, the purported transaction is void as against the official liquidator for reason of fraudulent preference. Your lordship, subject to correction, your lordship will not find any case of 531A made out, where, my lord, there is allegation of undervaluation or allegation of the transaction not being in good faith, which were onus on the official liquidator to discharge. Fraudulent preference is the only case made out. My lord, pleading is one thing, but the onus is something which is inbuilt in 531A. The court, my lord, in the first court, my lord, has held that pleading may not be there. It's all right. I can still look into any other provision. My lord, it was pointed out before the court, my lord, that there is no pleading of 531. Court said it's all right, need not be there. But the fact that the obligation or the burden of proof to discharge that there was undervaluation or the transaction not in good faith, that has not been discharged also. For that to be discharged, my lord, documents had to be shown that the transaction was not in good faith, and also, my lord, the property was undervalued. Nothing has been done. So this is the AO of the official liquidator. Must point out, my lord, in the AO also they've taken the point.
They have taken the point of limitation we have seen.
Yes, my lord. They've taken the point of limitation. But limitation, well, and my lord, if your lordship sees para 22, they had taken the point that the letter was, that letter of 2013 was written under mistaken belief.
Any case law you want
Yes,
to rely on?
My lord, before, if I show your lordship the agreement once. My lord, the agreement only has to be seen prima facie by your lordship, my lord. If your lordship sees, my lord, page 27, this is the agreement for sale. And the clause which is in issue, my lord, is to see whether, my lord, time was of essence. Clause 33, prima facie. Court, on the basis of this clause, has held that time was of the essence, and in 1998, my lord, the time has started running. My lord, clause 13 at page 33. The vendor hereby agrees to complete the sale and or transfer of the said factory within 31st December 1998. The said time of complete the transaction of sale may, however, from time to time be extended by mutual consent of parties. And my lord, if your lordship takes the order impugned once, my lord, in this regard, the finding of the learned court, my lord, I want to show that point, my lord, and then come to the my lord, your lordship is looking at the your lordship is looking at the order impugned from the
These, etc. After the winding up,
yes, my lord.
nothing can.
I'm not relying. Those can be held to be void. Those were, well, that's the discretion of the court, my lord. Court may, unless otherwise, hold it to be void. So there is.
You're not relying on.
I'm not relying on that. I'm relying on the the agreement for sale itself. It stands on its independent footing, my lord. Your lordship will see. Your lordship, let me go through the law, my lord. If your lordship takes first, my lord, to show even if there is a stipulation in the contract that it has the transaction has to be completed within a particular period of time, the other clauses, the relevant facts, has to be seen whether time was made of the essence or not, my lord. If your lordship takes the judgment of 2009-5 SCC 182. Well, if your lordship takes paragraph 4 of this judgment first, the appellant and the respondent entered into an agreement for sale of the property in dispute on 21st December 2005 for a sum of rupees 6 crore 99 lakhs, in which an advance of 2 crores odd was paid to the respondent at the time of executing the agreement for sale. One of the stipulation in the agreement for sale was the balance amount of consideration shall be paid to the respondent at the time of registration of the sale, which shall be executed within 60 days from the date of execution of the agreement for sale. There was a stipulated time. Now, if your lordship takes para 27, in a contract for sale of immovable property, normally it is presumed that time is not of the essence of contract. Even if there is an express stipulation to that effect, the said presumption can be rebutted. It is well settled that to find out whether time was the essence of the contract, it is better to refer to the terms and conditions of the contract itself. Although the contract here itself provides that the time can be extended from time to time. The learned court below, my lord, the first court has only seen the first part of the clause, not the second part, where the time could have been extended. The other clauses, the conduct has not been seen. Now, my lord, recent judgment of Supreme Court also on this point, my lord, 2214 SCC. 2022, volume 14, SCC 793. Your lordship will see paragraph 20. Well, this is the pre-amendment specific relief act case, my lord. Section 20 of the specific relief act pre-amendment, which confers discretion. Paragraph 20. My lord, the court, my lord, Supreme Court has, my lord, given the factors which has to be considered by a court while examining whether specific performance of an immovable property can be granted or not. In this paragraph. And then, my lord, I'm just showing, my lord, these are the considerations which ought to have been looked into, which will be looked into. And then para 27. My lord, court sets out, my lord, Kamal Kumar and Premlata Joshi, the several factors which are there. Then if your lordship takes para 27. The court should examine whether the plaintiff purchaser had in fact performed his part of the contract, and if so, how and to what extent and in what manner he has performed, and whether such performance was in conformity with the terms of the contract, the status of the parties, whether the plaintiff purchaser is a speculator in the property, who buys and sells property, whether his conduct reflects an attempt to gain on account of rise in the price of the property, hoping that delay in payment of full consideration would go to his advantage will be a relevant consideration. Incapacity of a defendant seller, whether the plaintiff purchases operating in property trade or financer, middleman, may also affect the exercise of discretion. Then para 29. Time, it is stated, is not the essence of a contract in a case of immovable property unless there are grounds to hold to the contrary. The doctrine is applied without being unfair and equitable to the defendant seller, as the court should not ignore that a person sells the property when he needs money and therefore expects the money in stipulated and reasonable time, which would meet the purpose of the sale. Well, in my case, well, 1.31 crores out of the 1.39 crores out of the 1.70 crores had been paid within the time specified, my lord. What only the execution could not be done, and I had been ready and willing to pay the 31 lakhs, a paltry sum compared to the whole amount, my lord, at the relevant point of time and continuously. I had been ready and willing. So time is of the essence, my lord, to hold, my lord, in a rather, my lord, without taking any evidence, at my lord, in this case, summarily, it has been held that time was of the essence, without looking into the terms, without looking into the facts of the case. Yes. So, my lord, on this point, my lord, where are you? 58-1, page Supreme Court 1, page 1. England এখনো contract codified, no judgment. যখন contract act reject করেছে, all their principles incorporated here. Here, my lord, in fact, if your lordship sees, in view of the conduct of the official liquidator, also the letter issued, my disclaimer application was like a suit for specific performance. In that sense, my lord, there was no refusal per se, said that you go ahead. So, my lord, the refusal had never come. I'd asked for disclaimer. If required, I could have, my lord, if court had called upon me to show, my lord, that I was ready and willing to perform, the constituents of specific performance of a immovable property are in fact present, I would have shown all that. But that was never shown. At a summary stage, time was of the essence and it was rejected. My lord, now, my lord, with regard to section 531A, although, my lord, that's not the case here, the onus. What will be the present value of the property? May or may not be relevant, but just as a matter of curiosity. I will have to find out, my lord. I have no idea. You have any idea? No. Very well. Proceed.
Property has never been, my lord, no valuation has been done as yet.
I see. Very well. What has happened subsequent to, my lord, because that appeal will also come before your lordship, my lord, while this appeal was being heard, this appeal has been heard, my lord. I was not briefed earlier. From what I see, this appeal had been heard by different benches on several occasions, and when it was at an advanced hearing stage, my lord, the official liquidator took out an application in 2015 to take possession of the property. That was stayed. That application was not given any effect. The court had said, don't proceed with. Then in 2022 or 23, my lord, a second application of the same nature was filed. And, my lord, the learned company court, so for whichever way, my lord, prejudice that, my lord, that this appeal is pending and the official liquidator has not taken possession of the property, despite the order of winding up being passed in 99, directed take possession tomorrow. I mean, it was in one day, my lord, the possession was directed to be taken. I think it was 5th of December, and on 6th December, the official liquidator was directed to take possession. An order was passed on 5th December, and 6th December, you take possession. Well, the company court directed that order. We had preferred an appeal. On 6th December, the order was stayed. Order of taking possession was stayed on 6th December itself. Official liquidator claimed that before the order was stayed, within that period, official liquidator had gone and put a lock. And therefore, official liquidator is in possession of that property.
Company judge's order was dated
5th December. Which year, my lord, I'm 5th December.
and next day it was stayed.
Next day, it was stayed. But official liquidator says that before it was stayed, within that period of time, they'd gone and put a lock
In Mysore.
in Mysore.
That in presence of the superintendent of the police.
So
And
that's
in presence of the my learned friends, my lord, representative.
May not be very relevant.
so
in
official.
this
The court also holds that in the division bench,
My lord, the
I will.
to pay 1 lakh of rupees for the security guard.
That's another matter.
That
So
is not
I will show. That is all before your lordship also.
Give us the case law.
Yes, my lord, case law. Yes. Now, my lord, the burden of proof is on the official liquidator to show, my lord, if it could have come under 531A at all, burden of proof was on the official liquidator altogether to show that the transaction was undervalued and not in good faith. My lord, I will show the parent judgment and then come to the company. My lord, under insolvency regulation, similar provision, regulation 35 was in play, my lord. AIR 58 Supreme Court. AIR 58 Supreme Court, page 1. Lord, if your lordship takes paragraph 4, a number of points were raised on behalf of the appellant, and at the threshold of the arguments, it was contended, and in our opinion, rightly, that the courts below had erred in throwing the burden on the transferee of proving affirmatively that the transaction impeached, namely the usufructory mortgage bond dated 18th August 1924, was supported by good faith and valuable consideration. The Judicial Committee of the Privy Council laid it down in the case of the official assignee versus Hu Sao Chu that upon a true construction of the bankruptcy ordinance of the Straits Settlements, section 50 and subsection 3, which in terms is similar to the provision of section 35 of the insolvency regulation, which is similar to section 531A, the onus is on the official assignee to prove that a conveyance which he is seeking to set aside was not made in good faith and for valuable consideration. Ever 92, volume 74, company cases 89. Now, while interpreting 531A also, which is identical to section 35 of insolvency regulation, it has been held, the same onus is on the official liquidator also. If your lordship takes 1992, volume 74, company cases, page 89. If your lordship takes internal page 22 of the judgment, which will be at the SCC internal page 22. Before I analyze this submission, I consider it necessary to refer to the leading judgment of the Supreme Court, indicating the approach which court is enjoined to follow in cases of this kind. In the case of N. Subramaniam Iyer and the 58 Supreme Court 1, the apex court dealt with the identical question under insolvency regulation. It was held by the apex court that the burden of proof was entirely on the official liquidator who impugned the transaction of the transfer. But if your lordship now takes, then good faith, all has been defined, they've been defined. And then if your lordship takes page 25, 2 lines from the top, taking an overall view of the facts and circumstances of the case, I hold that the official liquidator and the petitioner workmen have failed to discharge the onus to prove fraud. Here 531 was also there. Prove fraud or collusion or any other ground sufficient to vitiate the impugned transfer. 531 and 531A both were being considered. So, my lord, the transferee, I don't have a burden to show that the transaction was in good faith or it was for valuable consideration. If at all it has to be set aside, it is only for the official liquidator, not for me. Well, I'm not multiplying the judgments on this point. Now, my lord, this another fact here is, my lord, that apart from me paying the 1 crore 39 lakhs, I'm also in possession of the property. There is no dispute that at least from 99 till 2022, I was in possession of the property. Whether I'm still in possession or not, that is something which has to be decided, but that's neither here nor there for the decision under the disclaimer application. At the time when the disclaimer application was being decided, I was very much in possession, no dispute about it. And I was put in possession of this property pursuant to the agreement for sale. So there's also section part performance also comes into play. 53A also comes into play, Transfer of Property Act. And interest has also been created in my favor. I know 53A is always taken as a defense to an action which is being taken. Here, if at all, an action of under 531A was taken against me by saying that the transaction is void, I could also say interest has been created in my favor. I am in possession of the property. Not only have I paid substantial sum, but I'm also been put in possession of the property.
Yes.
Should I show, my lord, the deeds of assignment also, my lord, by which, my lord, I have been assigned ICICI's right? Well, it
may not be disputed. If not disputed,
It was never disclosed before the court below also.
Oh, never disclosed.
My lord, they have filed affidavits, but it's now on record.
No, if not disclosed, then why shall we, before Justice Patheria, why should we allow you to disclose it here?
My lord,
without 41 Rule 27.
The official liquidator has filed a supplementary affidavit bringing on record all subsequent facts. It is at their instance the supplementary affidavit has been filed, not my instance.
Let us assume you are a secured creditor.
Yes, my lord. Secured creditor, this property is mortgaged to me also. I agree, my lord, but I'm just saying, from a prejudice point of view, here, my lord, no purpose would be served. I am still the mortgage. I am the secured creditor in respect of this property.
Enforce your mortgage. Enforce your mortgage.
But that's a secondary part. That's a secondary part. So far as the disclaimer, that is why my lord, I did not press on that. I'm just saying that that's also a factor which could be considered.
If we dismiss your appeal, that doesn't stop you from enforcing the mortgage.
So, my lord, now, my lord, to summarize, the learned court below, my lord, on the premise of time is of essence, has held my transaction to be not enforceable. It has not been held that the transaction was bad, void, or voidable. Learned court below has held that the transaction was not enforceable. I could not get a specific performance of it. That was the only reason for which, my lord, the transaction was held to be not enforceable, nothing else. That, my lord, subject to, my lord, my submissions, my lord, according to me, time could not have been held to be of the essence, and 31st March was the date. That was, my lord, the parties, the agreement itself, the terms itself show, my lord, that the parties had agreed that the time could be extended from time to time for completion. That has not been considered by the court below.
Time is such a strange concept. Have you read A Brief History of Time?
I've not read it. I've seen that movie, though, my lord.
What's it called? On Stephen Hawking? What is it called?
Theory of Everything.
Theory of Everything.
Theory of Everything. Where the actor won the Oscar also for portraying. Eddie Redmayne, I think Eddie Redmayne. He won the Oscar for portraying Stephen Hawking also.
A Beautiful Mind was on Crowe.
Nash.
Russell Crowe.
Russell Crowe.
He won the Oscar, I think. For that portrayal, no?
I don't remember. I think he won it for that Gladiator. I'm not sure.
Pre-Oscar.
He's right.
Authority.
I think Russell Crowe, I think he won also for I think a year before only that Gladiator had also come. I don't recall, man. I'm not very sure.
Yes.
So, my lord, time is of the essence, my lord. I think the learned court has gone wrong while dealing with time is of the essence and court transaction to be void. Second, and most importantly, my lord, in this case, my lord, 531 has not been invoked. And it also could not have been attracted. That also is my case. And 531A has been wrongly invoked. Well, in summary, this is my argument.
Kindly provide me some time. Not today, but okay.
Why? Really?
But your lordship, first of all,
So, Mr. Chaudhary, whatever little you want to say, please tell us today.
kindly see page 36 of my supplementary evidence.
এগুলো নাও তো।
36 of my supplementary evidence.
Filed in the appeal.
Yes.
কি আছে দেখো appeal এ। Oh,
I have not taken your lordship through the subsequent facts.
sorry. We had fixed a matter at 12:45.
Then we'll come back. Well, I have not taken it. If your lordship wants me, I can take your lordship to the subsequent facts also after the disclaimer application. Well, because
May not be that
supplementary affidavit orders which are being relied upon are all subsequent to.
How will they be relevant? We don't understand.
In case, my lord, your lordship feels there's any response and required, then I will, my lord, answer those, my lord.
That is in respect of the court, my lord.
Anyway, can you come back at 2 o'clock? Finish it off, Mr. Chaudhary, because we'll forget.
2 o'clock, my lord, I am extremely sorry. I have to, my lord, attend court number 38, my lord, all company matters, my lord, was delegated upon me. That is, my lord, difficult.
হেজিটেশনও হয় না বলতে। ডিভিশন বেঞ্চ তোমার কাছে আসতে পারবো না। Go wherever you want to go. Hearing is concluded.
My lord, kindly keep it, my lord.
Hearing is concluded, Mr. Chaudhary.
Kindly keep it one day, my lord.
No. We don't appreciate this kind of conduct. Come back at 2 p.m. Call the matter.
Commercial division means specialty item number 13.
I had handed up, my juniors had handed up a compilation.
What are you feeling now? All right.
I'm better, just stomach.
We have your note, Mr. Bhattacharya, to keep your oral submission very short.
So your lordship would, section 13(1), your lordship kindly takes the Commercial Courts Act. An enabling provision, whereas 13(2) is a disabling provision. Because if your lordship kindly takes that compilation, I got the Law Commission report on this. But kindly takes page 76. This was what was recommended by the Law Commission. Section 14. But I'm sorry, I think the pagination would be at the bottom of the page and it should be 69. Has your lordship got that? But this was the section what was recommended by Law Commission. An appeal shall lie only from such orders passed by the Commercial Division or Commercial Court that are specifically enumerated under Order 43 of the Civil Procedure Code as amended by this Act and Section 37 of the Arbitration and Conciliation Act. Notwithstanding anything contained in any law or latest patent of a High Court, no appeal shall lie from any order or decree of a commercial division or a commercial court, otherwise than in accordance with the provisions of this Act. Now, my lord will kindly see what was recommended by the Law Commission. An appeal shall lie to the Commercial Appellate Division of the Jurisdictional High Court against decree of a commercial court, commercial division or commercial court, including a judgment on claim. But now, my lord will kindly see what the legislature has done. My lord, the registration removed this 50. My lord, this also has been amended in 2018. The present one, my lord, may be 2018 amendment, but I have an old Bear Act copy, which would, does your lordship use the SCC one copy? My lord, your lordship will find at the bottom under 13, this was the original. But substituted by Act 28.
It is there.
Yes, any person aggrieved by the decision. Your lordship would word the word decision, because there is no definition of decision in the CPC, and it can be of the widest amplitude. So in 2018, this was amended. This was amended to any person aggrieved by judgment or order of a commercial court below. Level of a district court may appeal to the commercial appellate court within a period of 60 days from the date of, my lord, we kindly mark the word judgment. Because what I have figured out, my lord, all decrees are not judgments. Judgment is of a much wider amplitude. And I will show the amendments to the CPC to that effect. There are certain decrees, because the problem has been created by the definition of a decree, which includes deemed decree. Well, for example, a decree, a rejection of claim on the ground of Order 7, Rule 11C, that somebody has insufficiently the registrar reports. I have the original side rules also. Registrar reports that this has not been paid. Your lordship will give him an opportunity, otherwise dismiss the suit. But that would be a deemed decree by virtue of the definition of decree in the CPC. For example, not filing in triplicate, Order 7, Rule 11EF, or a compromise decree. That is why compromise decree has been specifically excluded under Section 96. Those won't be judgments. So here, judgment would be of widest amplitude. What 13.2 in my respectful submission, my lord, intends to do is to restrict those decrees which are not judgment. Because the Commercial Courts Act does not define what a judgment or an order is. My lord, this proviso, my lord, was brought in, my lord, in view of Shah Babulal Khimji. Babulal Khimji, clause 15, the meaning of judgment, my lord, it was expanded, my lord, your lordship knows, and further, my lord, in Liverpool case, Justice S.B. Sinha also expanded the scope of judgment. This was done only for appeal against orders, to restrict it to Order 43, strictly to Order 43, nothing else. But a decree, which would also be a judgment, would come under Order 13, Rule 1, Section 13.1. If your lordship kindly takes Section 2 of this Act, 2 subsection 2. The words and expression used are not defined in this Act, but defined under CPC and the Evidence Act, and shall have the same meaning. So judgment and decree, my lord, will have the meaning assigned to it by CPC. My lord, will kindly take the CPC once. First, your lordship kindly takes 2 subsection 2. Decree means the formal expression of an adjudication, as your lordship, Justice Rai got, which so far as regards the court expressing it conclusively determines the rights of the parties with regard to all or any matters in controversy in the suit, or maybe either preliminary and final. But this is where the problem is created. It shall be deemed to include the rejection of claim and determination of any question under, but shall not include and dismissal. Now, my lord will thereafter find the definition of judgment, Section 2, subsection 9. Judgment means the statement given by the judge of the grounds of an order or a decree. So a decree and an order both envisages that it should contain a judgment. So what we actually appeal is from judgment, and I will show the amendment to CPC with regard to that. And my lord, lastly, order section 2, subsection 14 means formal expression of any decision of a civil court which is not a decree. Now, if your lordship kindly takes the CPC ones, order 20, the lordship kindly takes order 21. Order 20, Rule 1. This is how a judgment is pronounced. I'll not trouble your lordship with the entire thing. My lord will kindly take Order 20, Rule 6A. This was introduced.
Yes.
Order 26A, every endeavor shall be made to ensure that the decree is drawn up. Now, this is procedural. An appeal may be preferred against the decree without filing. Now, my lord, Order 26B was also introduced in 2002, where the judgment is pronounced. Copies of judgment shall be made available by the parties to the parties immediately after the pronouncement of the judgment for appeal, for preferring an appeal on payment on such charges as may be made in this suit. My lord, will kindly see the notes on this clause. I have just got shortcut on this. My lord, this was the Malimat Committee recommendation. Why 6B was brought in? Because what we appeal against is a judgment. Even, your lordship, this would be evident. Even there was an amendment to Order 41. I have the new book. New book does not have what it was there before the amendment in 2002. My lord, before the amendment, it would read as every appeal shall be preferred in the form of a memorandum signed by the appellant or his pleader and presented to the court or to such officer as it appoints in this behalf. The memorandum shall be accompanied by a copy of the decree. Earlier, this was the clause. Now, your lordship will kindly see Order 41. This has also been done away by providing judgment. Similar amendments were made to other provisions of Order 41. My lord, that book I have handed it to your lordship, my lord. My lord, which is there in my notes, my lord, page 5 and 6, I have indicated it. If your lordship kindly takes Order 7, Rule 11 once. A, B, D would require your lordships to adjudicate. There has to be an adjudication, which is a judgment, basically, my lord. TEF, it is no adjudication. That is what is being sought to be restricted by 13.2. 13.1 is an enabling clause, 13.2 is a disabling clause. Now, my lord, this has been considered by the Delhi High Court. But here, my lord, the Delhi High Court, in my respectful submission, my lord, went a bit. My lord, will kindly take page. एक compilation में कोথায় আছে বলতো দিল্লিটা?
2017 case.
My lord, kindly gives me a moment. My lord, it is at page 149 of the compilation. The division bench of Delhi High Court, my lord. Paragraph
149.
149 it starts, my lord.
2017 SCC online 6955 of the learned amicus's report, page number 149.
149 is to be found where, at the top or
at the top? So
here 149 is the last page of some Supreme Court decision.
May I just?
Oh, sorry. 0149.
Lord, Justice Banerjee, may I just check your lordship copy, my lord? My lord, here it is 150 for your lordship. I'm so sorry. While making the pagination, there might have been. My lord, takes paragraph 27 of this report. No. No. The provisions of appeal as contained in CPC fall within part 7 thereof, section 96 to 99A, fall under the heading appeal from original decrees. Section 100 to 103 falls under the heading appeals from appellate decrees. And section 104 to 106 falls under the heading appeals from order. It is therefore clear the appeal falls into two broad categories: appeal from decrees and appeal from orders. The category of appeal from decrees is further subdivided into two categories: appeal from original decrees, appeals from appellate decrees. It is clear that the appeals as under the code. This is so because the judgment as defined in section 2(9) of CPC is merely the statement given by the judge on the grounds of a decree of order. It is in this backdrop that we are aware that the expression judgment appearing in 13(1) is a misnomer, and that in fact it pertains to a decree because appeals can only be from decrees or orders. Another thing which is clear that the word judgment and the order has been used disjunctively and cannot be interchanged for each other. This is particularly so because of the expression as the case may be, as the case may be, which follows the expression judgment or order. It is clear that the word decision includes both. Now the decision has been removed. Now it has been, after 2018 amendment, it is now judgment or order. Includes both decrees and orders. It is clear an appeal under CPC is provided only from decrees or orders. The Delhi High Court does not take into consideration Order 7, Rule 11, C, E, F, consent decrees and stuff like that. Now, my lord, what it essentially seeks to do is to, till the order or something attains finality, my lord, that is not appellable. That kindly gives me a moment.
What is the nature of the order in our case? I've forgotten.
Lordship, this was an order by virtue of which which was granted under section 12A was revoked and my suit was dismissed.
Enter A. Huh? Mr. Bhattacharya, today time is up.
I think, my lord, I have almost concluded. Only one judgment I would show what it seeks to do. But at any day, your lordship.
Tell us what is your convenience, Will.
Can I come back on Friday then?
Friday? Friday ki কিছু fixed ticks আছে দেখো তো।
Friday. Oh, my lord, Mr. Chakravarti.
I wouldn't be in town for a professional
Then
committee.
tell us.
As for Mr. Bhattacharya,
Tuesday দেখো, Tuesday দেখো।
তাহলে Wednesday. Wednesday.
Wednesday? Fixed আছে। We can, Wednesday we can keep it in the second half. 4 o'clock. How long will you take? 15 minutes.
I have 15 judgments to cite.
15? 3:30. Let's finish it off on Wednesday. The amicus curiae is arguing in favor of appealability, isn't it? So you may not have much to.
Lordship, I will just take 5 to 10 minutes to supplement.
Very
To supplement just to,
sure.
if I may use the term, piggyback on what he's.
Likhun. Learned amicus curiae resumes his argument but does not conclude. Paragraph lists the matter once again on next Wednesday date thou, marked 3:30 p.m. No. No.
I can understand the apprehension.
Today is unusual. Normally Wednesday.
Can it be on Fridays?
Yes, Fridays foregone conclusion.
What's happening to 5 minutes?
But my lord, in the morning, my junior my lord had mentioned my lord, a matter my lord, for leave my lord, from the urgent determination of Justice Bhattacharya. Now my lord, what
Well, if she couldn't answer her queries, probably.
I know, my lord. My lord, the urgency is, my lord, today, my lord, the BLRO, my lord, had came to the suit property, my lord, and had, my lord, with large number of police force, my lord, for effecting demolition. Now, my lord, today my learned junior had written a letter. A verbal assurance has been given by the BLRO that he will stay his hands till Friday.
Why, you have suffered a demolition order?
Exactly. My lord, what happened, my lord? My lord, a writ petition was filed wherein, my lord, a direction was given for consideration of the representation for alleged, my lord, filling up of a water body. We have already approached the...
Serve.
Yes, I'm grateful to your lordship.
For judgment, item number 1.
We have allowed the appeal.
Great.
We found that the Honorable Judge does not have determination on that day.
Grateful. Nothing on merits. On
You
that
have to
day,
go back, get it adjudicated again.
Perhaps we did not place the notification matter is not available on the internet.
No,
But
not the notification. The determination list was there. We checked up because we would not have entered into the merits at all if this was cleared. There was no opposition from their side to your submission that she had determination of both the commercial matters as well as the ordinary original civil jurisdiction. Commercial matters only in respect of suit was there. Section 34, other arbitration matters was with some other honorable judge. So that is the only point which we have
so it
decided on.
requires a fresh hearing before the learned judge having determination in the matter. We have not expressed our opinion on merits at all.
But you has relegated it to the section 34 court.
Yes.
Grateful.
Has to be heard again.
Grateful. Obliged.
Good for you.
Grateful.
Chalo.
I hope this is not on YouTube. The
Huh?
client.
बिल्कुल ठीक। कोई पड़ा तो এসছে কি লোক এসছে করো কর কেন কল করতে বলেছি You had appeared in the morning. Number 4. We still haven't got the papers. Try once at 3:25 before we rise. Come. Hey, Shahid. হ্যাঁ কেন পাচ্ছি না কেন কি কেমিক্যাল পড়ে Yes, the continuing matter. Mr. Chaudhary, we only want you to hear, basically, we wouldn't say only on limitation, because that is one point you had taken in your affidavit in opposition, and that is the main ground on which the learned judge has disallowed their application.
And my lord, section 531A also, my lord, also one of the ground 531A, my lord, for
531A.
531A.
Is your microphone switched on?
You know, my lord, it is switched on. Switched on. My lord, the first agreement for sale, my lord, my respect to submission and agreement for sale cannot be treated as ownership, because agreement for sale cannot transfer any right, title, interest over the properties.
They are not treating
Until
it
and
as
unless,
ownership.
no, my lord,
Yes,
the basic point is, my lord, that first day of April 1995, an agreement was entered in between the company and my lord, the my lord and friends client. Now, within a period of 1 year, my lord, the company went into liquidation. Once the company went into liquidation, the company, my lord, the official liquidator is the custodian of the property. And my lord, this
correct. Correct. করেছি তো এরকম। No, but it is our duty to take. কি স্ট্যাম্প ছিল দেখালো যেটা? Your agreement for sale, 1st of April 1995.
Yes, my lord.
Was it sufficiently stamped?
It's on a 100 rupee stamp paper. I've been trying to
non-registered.
locate the stamp 1995. What was the stamp payable in Karnataka, Maharashtra, Mysore? I've not been able to figure that out yet. Whether there was any stamp duty payable at all on agreement for sale in Karnataka in 1995. That I've not been able to. There's an amendment of 2001 in Karnataka, which is there. The 1995, I've asked some of my friends in Karnataka to send me. I've not yet been able to get that. I've not seen that, my lord. From the document here, it's
It's Bengali যেটা আছে কর্ণাটকে নাও
on Google. I've not been able to find, my lord.
Do you think if we give you some time, you will be able to find out?
My lord, I've asked some of my friends in Karnataka to look at online. I've not been able to find.
Very simple issue, really.
Yes,
Nothing
my lord.
complicated.
Not very. It's simple. The old book has to be found. That's
So
all.
that way, Mr. Chaudhary will also. What judgment?
23 judgment. If it is unregistered, my lord, it cannot be said to be transferred. My lord, any
No. They are not saying the property has been transferred. Question is, if it is not sufficiently stamped, should we impound it? Can we look into it? Can it be taken in evidence? These are the points.
Although the first court did not go into that.
No, but this is
First
a
court did
question
not
of
go into
public
that.
policy also.
I agree, my lord. That's why I was trying to look at online. I have not been able to find it.
Therefore, if we give you a date next week,
I'll search for it.
He was also asking for time. He will also get time. Huh?
I'll try and find it, my lord.
Hey,
I'll ask for an old book. Old book will be required. That's all.
Old is gold, as they say. Mr. Mukherjee, learned counsel representing the appellant, has concluded his opening submission. Paragraph, Mr. Chaudhary, learned advocate representing the official liquidator, begins his argument but does not conclude. Paragraph lists the matter once again. Next Wednesday? তারিখটা দিয়ে দাও। এটাই ভালো। You come fully prepared, Mr. Chaudhary.
Over the weekend, I was searching for this, but online I couldn't find it, and I've asked some of my friends in Bangalore to see if they can get hold of old act. They'll be able to do it, I'm sure, but they've not yet reverted back to me. Online, I couldn't find any.
No.
Your Lordship, I am appearing on behalf of the appellants.
Yes.
Your Lordship, we had directions to file reply to the supplementary affidavit filed on behalf of the respondents. Unfortunately, the appellant was having some medical issues and thus could not commit with us. We are seeking time only till Monday. We will surely file our affidavit in reply by Monday.
Monday we will grant you.
Earlier also they have taken time, 2 times he has been dismissed for default.
Mental issue is saying what can be done.
Yes, Lord.
We have also, he was
involved and he was thereafter absorbed in the same hospital as a public relation officer. Such a mental issue.
On the now, although the extension of time to file his response to the supplementary affidavit of the respondent was obtained earlier by the appellant, comma, on the prayer made on his behalf, comma, peremptorily we grant further extension of time till Monday date the comma, when the matter will be listed again.
In the meantime, the execution may proceed. The execution
is listed for tomorrow.
because the matter is listed. They will again come and ask for time.
Your Lordship, it's only till Monday, Your Lordship.
Monday, if they again ask for time, we will clarify. Remind us.
Yes, Your Lordship. Much obliged, Your Lordship.
Same order in court.
Duto separate order.
Item number 16.
For the appeal, can you see the last order because respondent was not available at his residence permanently. So we got information that he is working somewhere in Bangalore. Now today I received the message from my client. Yeah, they found out the address. So give me some time. So I will.
How much? Tell us.
3 weeks. 14.
Thou order
Can you see the
order
last
to thou.
order? Because I don't want to do ex parte. Let them come.
Read order dated June 16, 2025, paragraph. Learned advocate for the appellant tells us today that the respondent's address in Bangalore
Yes.
has been ascertained.
Yes.
Stop. He requests for 3 weeks' time to effect service on such address.
Right.
Paragraph lists this matter once again on Kaushik
14.
blank 3 weeks. 3 weeks.
3 weeks.
Stop. On that date, affidavit of service should be filed in court.
Fine. My lord.
Call.
Item number 17.
Item number 17, I'm appearing for the appellant petitioner, my lord. This is my application under section 37 of the Arbitration Act. My lord, this is in relation to
Paper books have been filed.
yes, my lord, paper books filed.
Yes.
My lord, the respondent, I have given them notice about the mentioning before including the matter in the list. They have not responded, my lord. And my lord, I'm led by Mr. Rupak Ghosh. If my lord so pleases, this matter can be taken up. It is ready for hearing.
Where is Mr. Ghosh?
And Mr. Ghosh, I believe he's not in court at this point. But my lord,
No, you know who is appearing in this matter.
my lord, Mr. Saurabh Mukherjee was appearing in the section 34 stage. My lord, we have the present advocates. We had given them notice. Initially, the advocate on record was Mr. Rajesh Upadhyay, but there was a change. We've given the present advocates a notice while mentioning for inclusion in the list.
Were they present at the
No,
time?
my lord, they weren't present.
Who are these advocates?
Lord, I do not have the name with me. My advocate on record has the names.
Serve another notice.
I will do
Come
that,
back.
my lord.
Lekho, the respondent is not represented.
Respondents.
Respondents are not represented. Stop. Paragraph. Let this matter be listed again on Monday, date thou. Stop. In the meantime, learned advocate on record for the appellant shall serve a notice on learned advocate on record for the respondents, intimating that the matter shall be listed again on such and such jeta holo date ta, and that on that day, if the respondents are not represented, comma, the matter is likely to be heard ex parte.
Lordship, I'm appealing for the respondent. This is the matter against KOPT, and Mr. Tilak Bose was arguing, giving his reply to our arguments. I'm being led by Mr. Chaudhuri. But
You are for the respondent.
no, I'm for the appellant.
Appellant.
The
Pass
respondent.
over. Pass over.
I'm appearing to the respondent with section 9 application where the advocate Shah was making submission for. Section 8 rejection arbitration.
Very well. Pass it over.
I don't know. I don't know.
25.
Lordship, I am praying for not today in this matter. 27.
7 and 28, Your Lordship, this has been going on for a very long time. That the appellants are taking time in the trial court by saying that the appeal is pending. And every time, Your Lordship, the matter comes up here, they have some or the other excuses going on.
Why? What is your problem today?
Your Lordship, I am led by this in this matter. I am led by Mr. Dheeraj Trivedi. He's on his legs before court room number 26.
We are passing it over. Inform him.
27.
Number 27.
No, Mr. Trivedi is in 26.
26.
But, bole na. 27, 28, nobody is here.
Yes.
Pass it over.
Your Lordship, 27, 28.
27, 28?
Appellant.
CAMAC agency?
Well, I'm led by Mr. Mitro in this matter.
Yes. They are making a grievance.
What is your grievance? Well, your Lordship will. Mr. Mitro is not there, my lord. Here, my lord.
In town. He's not in town.
He's in town. He's
not in court.
Not in court.
Not in court.
Not in High Court right now. Not in High Court.
Tell us. He says that citing pendency of this, your client is taking time in the executing court or something like that. Trial court.
My lord, on Monday we'll do it. Your Lordship
Do
will
it.
Kindly.
No, we are ready with the matter.
Chance for them, or else let the appeal
On
be
Monday we'll do
dismissed.
it. If Mr. Mitro is not there, I will start.
Yes, you will do. Accommodation is prayed for on behalf of the appellant. Stop paragraph. On behalf of the respondent, comma, learned advocate makes a grievance that adjournments have been obtained by the appellant on several occasions. Stop. Citing pendency of these appeals, comma, the appellant herein is also seeking adjournment before the learned trial court. Paragraph. Let this matter stand adjourned peremptorily and be listed again Monday. Monday date to the other.
Grateful, Your Lordship.
If your senior is not available, you will do it. And I have noticed something.
This is Mr. Abhijit Mitro for the appellant and Mr. Anindya Mitro for the respondent.
Oh, really?
Yes, my lord. This matter is.
So her immediate senior is probably Mr. Roy Chaudhary. I have noticed some young learned advocates walking on the streets and reading mobile phones messages. So those who do that will understand. I will not name them. Please don't do that. It's very dangerous. It really is.
And my lord, I forgot to say, Mr. Riju Ghoshal, he's told me to inform you that Russell Crowe did not win the Oscar
for Beautiful Mind.
Beautiful Mind. He won it for Gladiator.
Gladiator.
For Gladiator.
Please convey heartfelt gratitude to him.
29 and 30.
Item 29 and 30. One is an appeal from decree, one is from an appeal from order. The Lordship had heard this substantially.
Yes, yes. This bench only heard it, no?
Lordship, if I am correct, Your Lordship, the other bench had heard it. Mr. Sabyasachi Chaudhary had concluded for the appellant.
So you have a choice, you can do it afresh, do it.
Your Lordship will do it afresh. Lordship, only humble request since Mr. Chaudhary is in some personal difficulty.
I know that, I know that.
First week of August, anytime, Your Lordship.
When? After 4th August?
Very well.
4th August, Gurudha.
Grateful, Lordship.
In 31, I am for the appellant Lordship, Mr. Avinash Kankani is appearing on behalf of Milord appellant. If your Lordship, Milord, kindly pass it over on fast call, Lordship.
Yes, pass over. Next.
My lord, in this matter, my lord, I will request my lord to take it up on the 28th of July.
Very well.
This has to be tagged with that matter, and Mr.
Done, Mr. Mukherjee, 28th.
I'm grateful to my lord.
Tagged with some other matter?
Yes, my lord, because it's same order has been challenged on the basis of that section 283 of the Indian Succession Act, my lord, when the property is situated outside.
Oh, I see.
My lord,
Mr. Joyanto Mitra.
Mr. Joyanto Mitra, senior advocate, is appearing in that matter. This is a separate matter, but same question, my lord.
Item 34. This is the appeal from decree.
Remember, 3 appeals, yes.
It is very important, my lord.
Where are the other people? Get them, we'll take it up. Nobody else is there.
Yes. My lord, since in the last occasion, the impugned judgment was sort of gone through. My lord, in the next call, if nobody is there, I will start it because I also have a cross objection. At least I'll start pacing the judgment all over again for the benefit of my lord. This is right.
Yes, you have to do that. This is a different bench.
Judgment, it will not take much time.
Let us take this up then. Let us take this up. Mr. Ganguly, please ask your clerk to inform the other learned advocates. You can take it up now. করে দাও, ধরে ফেলো।
From degree, item of 35, 37.
কালকে কনফারেন্স এসেছি, কন্টেম্পোরারি খাচ্ছি আমরা। আমি
My lord will find judgment on page 154. 154. It must be there in the memorandum of opinion also. I am technically the respondent in the appeal of Citibank and Shonali Mujumdar.
You are Shonali?
I'm Shonali.
No.
The plaintiff decree holder. I'm placing this in their absence because, as I told your lordship, we also have a cross objection. It's 1 crore which has been directed to be paid by Citibank. We say no. Decree should have been passed jointly under Citibank should have also been made liable for the entire amount because there is a finding in the court below that they are guilty of it.
So the decree is against whom?
The
decree is against Shonali only.
And Shonali is represented by Aniruddha Mitra.
At least, my lord, let me play, in case they don't come, let me place the judgment and then keep it on top so that next case.
Yes, because this has been taken up on several occasions. শেষ করতে হবে খুব একটা বিশেষ কিছু নেই ব্যাংক এসছে ব্যাংকের কস্ট হয়েছে
Oh, my lord, the memorandum of the next thing. Plaintiff has filed the present suit, praying for a decree for a sum of rupees so and so against the defendants along with interest. Mr. Khogindra Pal Chaudhary and Usha Pal Chaudhary, both since deceased, had 6 children in their wedlock, namely Sri Jyotirmay Pal Chaudhary, my client, the plaintiff herein, Srimati Ranu Talukdar, daughter, Srimati Bani Rai, daughter, Chinmoy Pal Chaudhary, son, Mrinmoy Pal Chaudhary, since deceased, and Srimati Shima Pal, Srimati Ranu Talukdar, one of the sisters of the plaintiff, died on so-and-so, and one of the brother of the plaintiff, namely Mrinmoy Pal Chaudhary, died on 16th November. The wife of Sri Mrinmoy Pal Chaudhary, since deceased, being Shamuli Pal Chaudhary, also passed away on 26th.
মাইক্রোফোন তো কাজ করছে না
Mrinmoy Pal Chaudhary.
নো তো মাইক্রোফোনটা খারাপ হয়ে গেছে
I'll speak in this one.
খারাপ হয়ে গেছে
Well, at the last line of the second paragraph,
yes
Sri Mrinmoy Pal Chaudhary and Shamuli Pal Chaudhary, both deceased, had no issues. Shamuli Pal Chaudhary, since deceased, died, leaving behind several debts and securities. The plaintiff, on behalf of his surviving brother and 2 surviving sisters, as well as on his behalf, had filed an application under Section 377 of the Indian Succession Act before the Learned Court of District Delegate at Alipur for grant of succession certificate with respect to the debts and securities, that is, diverse savings bank accounts, fixed deposit accounts, and others, and other post office accounts of Shamuli Pal Chaudhary, wife of late Mrinmoy Pal Chaudhary. On 10th January, the plaintiff came across a letter issued by the defendant number 1 to Srimati Shamuli Pal Chaudhary, since deceased. This is where the story really starts. Since deceased, regarding operation of the bank account of Srimati Pal Chaudhary with the defendant number 1, that is Citibank. On receipt of the said letter,
sorry Shonali Shamuli's sister
Shonali is Shamuli's sister.
Shamuli's sister
Yes.
and how is Shamuli and your client Jyotirmoy
Shamuli is my sister-in-law, my brother's wife.
sister
My brother's dead, Shamuli is dead. Both are dead. And I have obtained a letters of administration, a succession, my lord, so that I can administer and take care of all the properties on behalf of the other heirs and legal representatives. That is an admitted fact that is on record, which was to the notice and knowledge of all. On receipt of the letter, the plaintiff on 13th March 2009 informed the defendants number 1 that an application for grant of a succession certificate had been filed by the plaintiff with respect to the debts and securities of Shamuli Pal Chaudhary, and appropriate directions for operation of bank account would be given to the defendant number 1 by the plaintiff only after grant of succession certificate. On 18th March, the defendant number 1 called upon the plaintiff to provide death certificate, relinquishment deed, etc. to the defendant number 1, so that the account of Shamuli Pal Chaudhary, being account number so-and-so, could be closed and the accounts would be transferred to the plaintiff. I shall show your lordship these letters. They are very important and play a crucial role. These letters are not disputed. They were all received by the bank. The Learned Court of District Delegate at Alipur has granted succession certificate in favor of the plaintiff, and in the said certificate, the bank account of Shamuli Pal Chaudhary with the defendant number 1 was one of the subject matters. On receipt of the succession certificate, the plaintiff had visited the office of the defendant number 1. The plaintiff was informed by the defendant number 1 that the account of Shamuli Pal Chaudhary since deceased has been closed and the proceeds thereof had already been handed over to the defendant number 2 sometime in the month of October 2009, being the nominee of the said account. When the plaintiff came to know that the defendant number 1 had released the amount in favor of the defendant number 2, the plaintiff had submitted a letter dated 16th January informing that the defendant number 1 had illegally and wrongfully released the said amount in favor of the defendant number 2, in spite of having knowledge that the plaintiff had filed an application before the appropriate court of law for grant of succession certificate, and accordingly the plaintiff had filed the present suit. On receipt of the writ of summons, the defendant numbers 1 and 2 had appeared in the matter and filed their respective written statements. As per the case made out by the defendant number 1 in the written statement, the plaintiff does not have any cause of action against the defendant number 1, and the proceeds of the bank account of Shamali Pal Chaudhary since deceased had been handed over to the defendant number 2 as nominee of the said account in terms of 45 ZA of the Banking Regulation Act and the Master Circular on Customer Service in Banks issued by the Reserve Bank of India. The bank is now taking a stand as if they had no other alternative but to do what they did, because as soon as they receive a letter of demand or a demand for amounts lying in an account in respect of which there is a nominee, they have no other option but to give it over. But the facts belie the stand which they are taking now. The defendant number 2 in a written statement has made out a case that she is the own sister of Shamali Pal Chaudhary, since deceased, and being the nominee in the bank account of Shamali Pal Chaudhary, has received the proceeds of the bank account from the defendant number 1. As per the case made out by the defendant number 2, that from time to time, Shamali Pal Chaudhary had sold her properties, inherited.
Shamuli and Mrinmoy didn't have children.
No. So, inherited from her father, who was a medical practitioner having substantial practice in Chhapra, and the money received from the said properties had been invested in the said bank account with the defendant number 2. It is further stated that the money lying in the bank account of Shamali Pal Chaudhary since deceased with the defendant number 1 were the proceeds of the sale of inherited properties of Shamali Pal Chaudhary. The plaintiff and other family members did not have any right in respect thereof, and the defendant number 2 is entitled to inherit the same in terms of section 15(2)(a) of the Hindu Succession Act. It is further stated that according to 24th October, the defendant number 1 had released a sum of rupees so and so to the defendant number 2. On the basis of the pleadings of the parties, the following issues have been framed. But I am not placing the issues. It is very apparent what the issues are and what they are going to be. Kindly come to internal page 7, paragraph 9. The plaintiff has examined himself as PW1, and during his examination, altogether 13 documents were marked as Exhibit 1 to Exhibit 13, which were as follows. My lord, the letters and all, I shall have occasion to place all this before your lordship when I'm arguing my case after they're finished. So I'm not going through this list by reading it out before your lordship. Paragraph 10. The defendant number 2 has examined herself as defendant number 1, and during her evidence, 3 documents were marked as Exhibits A, B, and C. Account opening form, original copy of acknowledgement of nomination, various receipt copy in favor of Shuchandra Mojumdar, Institute of Medical Sciences. Nothing about sale amounts from father's property, not a single document given, and as your lordship will see, no evidence also led. In fact, there is total confusion. The defendant number 1 has not adduced any evidence on its behalf, the bank.
If Shamuli died intestate, who would be the beneficiaries of her under the Hindu Succession Act?
My lord, under the Hindu Succession Act, my lord, Shamali would, the Shamali's sister, if it was her property which was got directly from her father's side, Shamali's family. But here, it was a joint account with the brother, and I had a succession certificate in my favor, which was admitted and acknowledged by them. My lord, which was contested by them. It was contested by them. That is another very important factor my learned brother points out, my lord. It was contested by them. The defendant number 1 has not adduced any evidence in its behalf. After the death of Shamali Pal Chaudhary, the plaintiff has filed an application under 377 of the Indian Succession Act for grant of succession certificate with respect to the Life Insurance Corporation policies, savings bank account, fixed deposit in state of Mysore, Rashbihari branch, 2 fixed deposits, etc. The application filed by the plaintiff before the learned court of district judge was duly contested by the defendant number 2. It is recorded. In the said case, the defendant number 2 raised objection regarding 2 fixed deposit accounts of Shamali Pal Chaudhary since deceased with the United Bank of India Gorihat branch, and on receipt of the said objection, the plaintiff had filed an application for amendment of the application for deleting 2 fixed deposits of Shamali with the United Bank of India Gorihat branch from the schedule of assets. So they told us these 2 fixed deposits were exclusively created for us and in our name. So, my lord, my clients immediately, my lord, deleted those 2 fixed deposit references from the schedule of assets in the application by filing an amendment application. Such is, my lord, the bona fides of my client, that if these have been given to you, you keep it. I will not touch it. Accordingly, the said accounts were deleted and the application of succession certificate was duly amended. Before the district delegate, the defendant number 2 had also raised the objection in respect to another savings bank account with Allahabad Bank, Rajbihari branch, on the ground that the same was inherited from the side of the father by the deceased, but the defendant number 2 had failed to prove the same. The defendant number 2 had never contended that the savings account bank number so-and-so, this is the subject matter of the present suit, was inherited property or was not the property of Shamali Pal Chaudhary, since deceased in the proceeding for grant of succession certificate. My lord, a very crucial line, a finding. The defendant number 2 had never contended that the savings bank account number so-and-so was inherited property or was not the property of Shamali Pal Chaudhary since deceased in the proceeding for grant of succession certificate. In the said proceeding, the defendant number 2 did not contend that she had any right whatsoever in respect of the savings bank account number so-and-so, the same bank account, with the defendant number 1, or any objection was raised regarding grant of succession certificate of the said account in favor of the plaintiff. So succession certificate in respect of that same account was granted in favor in her presence with her consent. She never said it should not come to me. The learned district delegate at Alipur had granted succession certificate dated 21st December in favor of the plaintiff, in which the present account was also the subject matter of the said certificate. So this account number and the proceeds therein were part of the schedule in the succession certificate. No comment whatsoever, no opposition whatsoever, no objection whatsoever, and it was the subject matter of the succession certificate. In the present case, the defendant number 2 tried to impress upon this court that the defendant number 2 is entitled to get the sum which was lying in the account of Shamali Pal Chaudhary since deceased with the defendant number 1 as per section 15(2)(a) of the Hindu Succession Act. The defendant number 2 has not produced any document or brought any evidence on record to prove that the father of Shamali Pal Chaudhary since deceased owned any properties, or Shamali Pal Chaudhary since deceased had sold the said properties and deposited the sale proceeds in the account maintained with the defendant number 1. During the cross-examination, the defendant number 2 admits that she has not submitted any document in support of her claim that the properties of the father had been sold and the proceeds deposited in the bank account. My lord, what remains to be said? She herself says so. And she fails to produce, my lord, any evidence or any document on record. The defendant number 2, during her examination, deposed that the flat number 6, Jotin Bakchi Road, had not been sold and was in her daughter's name. From the said evidence of the defendant number 2 regarding the sale of properties of her father by Shamali Pal Chaudhary since deceased and deposited, the sale proceeds in the bank account has not been proved. The defendant number 2 failed to prove that the amount lying in the bank account of Shamali Pal Chaudhary since deceased was inherited by her from her father. It is also not the case of the defendant number 2 that the amount which was deposited by the deceased in the bank account with the defendant number 1 was inherited from her father. As per the case of the defendant number 2, that the properties inherited by Shamali Pal Chaudhary since deceased from her father were sold, and then the sale proceeds were deposited in the account, Section 15 of the Hindu Succession Act 56 reads as follows. The property of a female Hindu dying intestate shall devolve according to the rules set out in Section 16. Firstly, upon the sons and daughters, including the children of any predeceased son or daughter and the husband. Secondly, upon the heirs of the husband, thirdly upon the mother and father, fourthly upon the heirs of the father, fifthly upon the heirs of the mother. Notwithstanding anything contained in subsection 1, any property inherited by a female Hindu from her father or mother shall devolve in the absence of any son or daughter of the deceased, including the children of any predeceased son or daughter, not upon the other heirs referred to in subsection 1 in the order specified therein, but upon the heirs of the father. And any property inherited by a female Hindu from her husband or from a father-in-law shall devolve in the absence of any son or daughter of the deceased, including the children of any predeceased son or daughter, not upon the other heirs referred to in subsection 1 in the order specified therein, but upon the heirs of the husband. In the case of Imana Viraghavama versus Subbarao, the Honorable Division Bench of Andhra Pradesh, we had cited this judgment, my lord. The above section, in effect, provides a general rule of succession to the property of a female Hindu dying intestate, and also two special rules of succession contained in clauses A and B of subsection 2. Under clause A of subsection 2, the property inherited by a female from her parents shall devolve upon the heirs of her father, in the absence of any son or daughter to her, while clause B thereof provides the mode of succession to the property inherited from her husband or from her father-in-law. These two clauses in subsection 2 are in the nature of exceptions to the general rule of succession provided in subsection 1. We are of course concerned only with clause A of subsection 2 in this case. Now, while interpreting the said clause A, it must be borne in mind that the female inheriting a property from her father or mother becomes the absolute owner of such property, and that she can deal with it in such manner as she likes. If she alienates the property inherited by her, it cannot then be said on her death that the property inherited by her is still available for devolution. But here she has not proved anything that she has inherited anything from her father. We are of the opinion that the expression property inherited by a female Hindu from a father or mother occurring in this subclause must be given a restricted meaning consistent with the absolute right of disposition of the female owner. The special rule of succession applies only in case the very property inherited by a female from a father or mother is still available at the time of her death. Otherwise, the rule does not apply. For example, if the identity of the property is changed, or if the property is substantially altered or improved, or if the property has been substituted, the said special rule can have no application. We are of the opinion that placing a broader meaning upon the said expression property inherited by a female Hindu from a father or mother would lead to much mischief not contemplated by the Parliament. If the property were to be followed by the father's heirs, irrespective of the change in the identity and a character of the property, it would give scope for unsavory litigation and complications. In the present case also, it is the specific case of the defendant number 2 that Shamali Pal Chaudhary, since deceased, sold the properties inherited from her father, and then the sale proceeds were deposited in the said account. Though the defendant number 2 has not proved her case, but assuming the defendant number 2 proved her case, then also the property inherited by Shamali Pal Chaudhary, since deceased from her father, becomes her absolute property, and the special rule will have no application. After coming across a letter dated 10th January of the defendant number 1, the plaintiff had informed the defendant number 1 by a letter dated 13th March that the plaintiff has initiated a case for grant of succession certificate with respect to the debts and securities of Shamali Pal Chaudhary, since deceased, and appropriate directions for operation of the bank account would be provided to the defendant number 1 after issuance of a succession certificate by the competent court of law. On receipt of the said letter, the defendant number 1 by a letter dated 18th March, well, this is very important. The defendant number 1 by a letter dated 18th March, this is Citibank, requested the plaintiff to provide death certificate, relinquishment deed, etc. by the defendant number 1 so that the account of deceased Shamali Pal Chaudhary could be closed and amounts can be transferred to the plaintiff. The plaintiff was granted succession certificate by the learned district judge at Alipur, and on receipt of the same, the plaintiff had approached the defendant number 1 for release of the amount available in the account of the deceased Shamali Pal Chaudhary. But the defendant number 1 informed the plaintiff that the defendant number 1 has released the amount in favor of the defendant number 2, as she is the nominee of the deceased Shamali Pal Chaudhary in her account. Claim application filed by the defendant number 2. This is a very crucial document which nails the case against the bank. claim application filed by the defendant number 2 with the defendant number 1 dated 7th October is marked as Exhibit 14. Claim application.
Calm application.
It didn't keep us calm. In fact, it rattled us even more. My lord, kindly see account bearing number so-and-so. I regret to inform you that Shamali Pal Chaudhary was maintaining the following accounts with your branch, died on 26/7/2008. Next page. Number 2. Late missing name is survived by the following legal heirs as per the law of succession applicable to late so-and-so at the time of his death. Name not applicable. He knows about the succession certificate. There is exchange of letters. He asks me for data. And then in this column, not applicable, relationship with the customer, not applicable, age, not applicable, address, not applicable. Conscientious bank. We confirm that legal representations in the form of succession certificate with respect to the estate of late so-and-so have neither been obtained nor contemplated to be obtained from any note, court or authority. Just see the extent of suppression. I hereby request you to pay the aggregate balance of a sum of rupees so-and-so lying in the account of Shamali Pal Chaudhary by way of pay order, etc. We are related to late Shamali Pal Chaudhary as her sister. 6. We hereby declare and affirm that we are entitled to receive the said amount lying in the locker safe custody account of late so-and-so in our capacity, everything blank. Six. And we further hereby confirm that all the representations made by me, us here and above, are true and correct, and there are no other claimants to the said account of late Mr. So-and-so. Kindly turn the page. Eight. We are claiming a sum of rupees blank lying in the locker as the natural guardian appointed by the court video order dated so-and-so, who is legally entitled to be the same, who is legally entitled to the same. We are enclosing
Yes.
My lord, clause 9. We are enclosing the following documents to facilitate the processing of our claim. Death certificate of the customer, indemnity from all the legal heirs. Driving license, voter identity card. Now, my lord, see how the learned judge deals with this document. In clause 2 of the said claim form, the details of the legal heirs as per law of succession is required to be provided. But in this claim form, it is mentioned as NA, not applicable. In clause 3 of the claim form, it is categorically mentioned about the succession certificate, letters of administration and probate, but the said clause remains unfulfilled. Clause 6 of the form is also unfilled, and the said clause is related to an undertaking by the claimant. Clause 8 of the form is also not filled in by the defendant number 2. As per clause 9 of the said form, death certificate of the customer and indemnity bond from all the legal heirs are to be enclosed along with the details of any and all other documents, but the defendant number 2 has not provided indemnity bond from all the legal heirs. The defendant number 1, without taking due care and caution, knowing, my lord, this is the case against the bank so far as we are concerned, without taking due care and caution, knowing that the form submitted by the defendant number 2 for release of the amount is not filled up properly and not enclosed the required documents, but has released the said amount. During the cross-examination answer to question number 90, the defendant number 2 stated that the application form was filled up by her as per the instructions of the bank. In answer to question 92, the defendant number 2 stated that the application form was filled up by her husband and she does not know anything about the same. In answer to question number 93, the defendant number 2 stated that she went to the bank with her husband and as per the instructions of the bank, her husband filled up the form and she put the signature on the form.
Everything is standard of care. Yes.
Under paragraph 18, the defendant number 1 relied upon section 45 ZA of the Banking Regulation Act, read with Master Circular dated 1st July, and submitted that the defendant number 1 bank had paid the money to the defendant number 2, being the nominee of the deceased Shamali Pal Chaudhary, upon fulfillment of all formalities and discharged its obligation towards the customer as also the nominee. But perhaps a greater untruth was never said. Clause 20.1.1 of Master Circular dated 1st July reads as follows. In the case of deposit accounts where the depositor had utilized the nomination facility and made a valid nomination, or where the account was opened with the survivorship clause, either a survivor or anyone a survivor, former a survivor or latter a survivor, the payment of the balance in the deposit account to the survivor nominee of a deceased deposit account holder represents a valid discharge of the bank's liability, provided the bank has exercised due care and caution in establishing the identity of the survivor nominee and the fact of death of the account holder through appropriate documentary evidence.
Nobody is disputing. In any event, the Master Circular cannot. That's your have it not affect. No. Let's say that I am taking this as trustee of the legal heirs. Correct. Yes.
May I proceed?
Yes, yes.
B. There is no order from the competent court restraining the bank from making the payment from the account of the deceased. But here the bank had knowledge of the pendency of the succession certificate proceedings. And they acknowledged it and asked for further details and records from me in that regard. It has been made clear to the survivor nominee that he would be receiving the payment from the bank as a trustee of the legal heirs of the deceased depositor, that a such payment to him shall not affect the right or claim which any person may have against the survivor nominee to whom the payment is made.
Mr. Bose, that is the general law.
Yeah.
Nominee generally receives as trustee of the legal heirs.
Yes.
Doesn't a nominee may incidentally be also a legal heir?
Yes.
That is different.
Grateful, my lord.
Yes.
Grateful. And the bank's own circular says so. Supreme Court has also said so. As per clause 20.1.1a of the circular, the bank has to exercise due care and caution in establishing the identity of the survivor nominee and the fact of the death of the account holder through appropriate documentary evidence. But in the present case, on careful examination of the claim form submitted by the defendant number 2 for release of the debts of the deceased as nominee, the said claim form, Exhibit 4, has not been verified by the bank with due care and caution, as in the form clauses 2, 3, 6, 8, and 9 have not been filled up properly, and no details of the other legal heirs successors of the deceased was provided. No indemnity bond of the legal heirs have been submitted, and in spite of the said discrepancies in the form, the bank has accepted and released the amount. Even both the defendants had the knowledge that a case is pending before the appropriate court of law for grant of succession certificate, in which the particular account was also the subject matter of the said case. This is very important. The particular account was the subject matter of the said case, which HON'BLE also knew. The defendant number 1, now Mala, this is the finding. The defendant number 1 as well as the defendant number 2 were well aware about the pendency of the said case for grant of succession certificate before the learned district judge at Alipur, as by a letter dated 13th March, the plaintiff had informed about the pendency of the case for succession certificate to the defendant number 1, and the defendant number 2 was a party to the case, as the defendant number 2 had participated in the proceedings. But in spite of the same, the defendant number 1, in connivance with the defendant number 2, had released the amount without waiting the outcome of the application filed by the plaintiff for grant of succession certificate. The defendant number 2 had not adduced any evidence in support of his case. Considering the above facts, the court finds that there was connivance between the final finding, connivance between the defendant number 1 and the defendant number 2 for releasing the amount in favor of the defendant number 1 in violation of the master circular, as well as after fully knowing fully well that a case for grant of succession certificate is pending. In case of Ramchandra Talwar versus Devendra Kumar Talwar, this was cited by us, Supreme Court cases, Section 45ZA merely puts the nominee in the shoes of the depositor after his death and clothes him with the exclusive right to receive the money lying in the account. It gives him all the rights of the depositor so far as the depositor's account is concerned. But it by no stretch of imagination makes the nominee the owner of the money lying in the account. It needs to be remembered that the Banking Regulation Act is enacted to consolidate and amend the law.
What does he say?
Whether it will go on.
It will continue till 3:30. Very well.
Because they are all here now. Furthermore, but by no stretch of imagination makes the nominee the owner of the money lying in the account. It needs to be remembered that the Banking Regulation Act is enacted to consolidate and amend the law relating to banking. It is in no way concerned with the question of succession. All the monies receivable by the nominee by virtue of Section 45ZA2 would therefore form part of the estate of the deceased depositor and devolve according to the rule of succession to which the depositor may be governed by succession certificate. The right to receive the money lying in the depositor's account was to be conferred on the nominee, but the nominee would not become the owner of such deposit. The said deposit is a part of the deceased depositor's estate and is subject to the law of succession that governs the depositor. In the present case, this court finds that the defendant number 1, without taking due care and caution, has released the amount of so-and-so in favor of the defendant number 2. And the defendant number 2, having knowledge that the plaintiff had filed an application for grant of succession certificate, in which the present service savings account was also one of the subject matters of the said case, but the defendant number 2 had suppressed the same and received the amount from the bank. The learned court of district delegate at Alipur granted succession certificate in favor of the plaintiff. Thus, the defendant number 2 is liable to pay the said amount of rupees so-and-so to the plaintiff, along with interest at the rate of 10% per annum from the month of November till the realization of the total amount. So this is the decree I get against the defendant number 2. I'm happy with that, but not entirely. The defendant number 1 has not taken due care and caution and released the amount in favor of the defendant number 2, knowing that the application form submitted by the defendant number 2 was incomplete and had not submitted required documents, due to which the plaintiff is compelled to file the suit, the recovery of money, and thus this court imposes costs of 1 lakh upon the defendant number 1. This is what I'm aggrieved by. When there is a finding that the Citibank acted dehors the law, that the Citibank did not take due care in getting everything regularized the way it should have been, they should have been made jointly and severally liable, which
Mr. Bose, if as per the case that you cited, Ramchandra Talwar,
yes,
which says the nominee has the exclusive right to receive the money in question. What difference does it make whether succession is pending, succession is granted? The bank hands over to the nominee, stands discharged. It doesn't affect any other person's right. You are well entitled to claim that money.
Yes.
But the bank has discharged its liability by handing over the money to the nominee, because the nominee has the exclusive right read with 45Z made.
Could the bank have acted in whatever way it feels like? I ask this question to myself.
No, according to law, it'll say 45ZA2.
No.
ZA2.
ZA2, not according to law. The bank, your lordship has seen the form, the claim form which they filled up.
That can't override ZA2. Can't override ZA2. Mr. Bose, all the bank needed to do is to identify, yes, this is the nominee. This is the nominee. More than that, nothing. According to prima facie what we
Let
feel.
the bank speak when my turn comes just to argue on this point. I shall
Yes.
develop this point further. Today was just a precursor, my lord, to show your lordship what the judgment is and what we are really aggrieved by. Because it is not just a question of getting a paper decree.
Is there a stay of the decree?
No. The bank was asked to put in security of 1 lakh, which they didn't. And cost, I did not run after.
You would do better to proceed in execution against Mr. Mitro's client.
If there is anything there.
House, whatever, we don't know. It's a decree you have obtained. You can execute.
Conjecture and past conduct gives us a precursor as to what lies in store for us.
We are, as of now, Mr. Bose, we are of the opinion that the bank, liability cannot be foisted on the bank, perhaps. Cost is a different thing for acting carelessly. That too, we don't know.
Well, I shall develop this point. Let the bank speak. Let Mr. Mitro speak. Since mine is the cross objection,
Yes, so
I shall sum it up.
So your argument has been recorded in the order itself. We'll hear Mr. Mitro, the real defendant.
The real defendant.
I'm sure.
I don't think.
But my lord will not be swayed by emotion.
No. No question. We are going by as we understand 45 ZA to be. That's all.
But my appeal is only limited. So far the nominee is concerned, I received the money as a trustee. I cannot improve on those because it's subject to the legal heirs' rights. Now, only thing with the defense that I intended to try to set up is that I use the word, I use that consciously, that this property, this money is from sale proceeds of a property of my father.
Your father, Shamuli's father.
Shamuli's father. My father and Shamuli's father. 3-4 dates is important, Malad. My brother-in-law, Shamuli's father, brother, he died Mrinmoy. Because Mr. Bose is Mrinmoy's brother. Mrinmoy died in November 2006. This account with Citibank was opened in February 2007. The nomination was done in March 2007. I have the precise dates, but only by going the month. So this account was opened after the death of the husband. The evidence which was led by the plaintiff tells that he accompanied Minmoy and my sister to Citibank to open the account, which could not have been, because Minmoy died much prior to the account being opened. I say this money comes from sale. My father hails from Bihar, Chhapra district. We sold some of the properties, and the money were kept with my sister, his sister's money. And if Lordship, the affidavit of asset which my sister left behind, which is a part of the proceedings before the succession certificate, is around 4 crores or 3 crores. What is huge money, cash. I have put questions to the witness plaintiff. Is there any other single account where the nomination is done of me? The answer is no. It is only in this account the nomination was done. This lady died a widow without a class 1 heir. No children. Now this is the only account where nomination was done. And there was a small account with UCO Bank, Gariyat branch, with some small amount, which I got released from the succession certificate. Now, evidence are given.
Very Hindu Succession Act.
Evidence are been placed that Shamoli had kept this. Shamoli was a doctor. Shamoli was a doctor, medical practitioner by profession. Shamoli's wish was that my daughter, Shonali's daughter, to become a doctor. And this 15 lakhs and odd, which is the figure, that is the only account where the nomination was done, and this money to be kept for her pursuing the medical course, whatever. That's the evidence given. And after withdrawal of this money from the bank, this money was actually used for that purpose. All documents of that medical colleges in Bangalore, Karnataka has been produced before the court. It's all on exhibited. It has been done. Now, the learned court has gone.
Withdrawn when? When?
It was withdrawn. Date of
No, which year? Just roughly.
And after the death, I'll just date of all. 2017. I'm just missing the date. Is not after success. Now, and thereafter, my daughter did her medical examinations, pursued the 5-year course, and today she is a doctor. Now, money has been utilized by us. This is the only why I'm saying this, because I am aware that what his nomination is, what is the legal heir's right. He is my husband's, or whatever, it's not mine, the Shamoli's husband's brother. She goes and files a succession certificate because there was intestate. She died intestate. I initially appeared there, contested it, and thereafter, obviously, my lord, I don't stay in Calcutta. I stay in somewhat Bhatpara or somewhere. To get out of a lawyer here, I appeared. What I found from the records, not happily conducted, if I may say. But be that as it may, I cannot say anything from that one. Today, this money, I received this money and I have utilized this money. Evidence is there. Now the source of this money, after this study, how I utilized this money. The source of this money, I had said that this money is from I sold away the father's property and this money is parked here. The learned judge proceeded that if the character of the property has changed, it has been now liquidated, or some other property is purchased from the then it loses the character, then it loses the proviso of section 15. The special line of succession, it loses that line of, if it loses. Now, my lord, here two things comes in. One is grant of a succession certificate in Mr. Bose's client's favor, I'll say is neither here nor there, if I may use it, because that is not giving a title, a grant of a succession certificate. It is a fact which has been placed before the court. It is not a right or a title to the property. Today, by a decree, it becoming he is the owner of this money, because the court passing a decree in a civil suit declaring the money is to be his money. Now, today, my lord, there is no evidence from the plaintiff side also that this money is from the husband's money. That is from Shamoli's husband, Mrinmoy's. After Mrinmoy's death, her wife inherited that money. There is no evidence. From my
husband's brother is a class 2 heir.
That
পেয়েছো আমাদের নেই নাকি হিন্দু সাকসেশন?
ওই দুটো একই বই হবে, একই বই হবে।
কার ম্যাটার ফিক্সড আছে? অ্যাপিলেট সাইড কোথায় রে? জিজ্ঞেস করো
কোথায়? মাথা ধরে গেল না, কেন ঠান্ডা লেগে গেছে।
ও রামপুর হবে না তো, কি হবে 15 মিনিট? You are in Mr. Mukherjee's matter, Mr. S.N. Mukherjee. There's a 3:30. No use. In 15 minutes, what will you do?
Subject to correction, this was heard by a different bench.
Oh, that got it.
That was part heard matter.
No, it's not part heard. So you see, I would suggest you start afresh.
We'll have to
Rather than trying to get it assigned. Even if you get it assigned, 2 division benches will have to break.
No point. No point.
So we'll fix another time and date. You have to do it afresh.
But I'll inform Mr. Mukherjee. In that case, he'll have to start. I had to start.
He'll have to start.
Yes,
He'll have to start.
I'll inform him.
Thou.
Yes, sir. Or do you want it fixed when he's around?
Yeah, when S&M is there.
যে কোনো দিন একটা 3:30 সময় দাও।
Oh, Arbitration, I don't know if you can start today.
Well, actually, not today, next day fix for him,
29 July. Today is 23rd. 29 at 3:15 same time.
Very well, minute. 3:15 minute.
Mark করে নাও।
29.
29 3:15. And pray for everybody's good health.
Mr. Mukherjee may have problems on that day.
My lord, I'm being told Mr. Mukherjee has very well, my lord, 3:15 on 29.
Decide. Make up your mind.
I'm making up my mind. It's the instructions that I'm getting, but my lord, 29th is
Then we know he has difficulty.
always cooperate. Grateful, my lord.
He ordered fixed for you.
That's it. We'll continue till 3:30.
Yes. Now, the schedule. দুটো বই পেছনে।
কি হলো?
We have given 2 books. দুটো বই।
ঠিক আছে, ও উঠবার আগে করে দেবো।
Yes, 10 minutes. The schedule 1 and schedule 2, class 1, class 2. But the heirs, the class 1 records son, daughter, widow, mother, son, daughter, predeceased, son, daughter, predeceased, daughter. So it is all on son, daughter, widow, and mother, and then thereafter.
Yes.
This is class 1. Now class 2 is father. There was no father. Now today, my lord, we are in the succession. It is of the section 15 will apply with the female Hindu or father, sons, daughters, father, son না এখানে 15(2) এ চলে যাবে রেড না এখানে 15(2) দেখতে হবে just come
section 15 ই দেখতে
now lordship will not find out have to come to section 15
yes
because section 15 is for general rule of succession in case of a female Hindu because the succession certificate was in the goods of Shamoli Pal Chaudhary
to male.
This class 1, class 2 is mainly male. Female. Firstly, upon 15, upon the sons and daughter and husband. B, secondly, upon the heirs of husband. Third is upon the heirs of mother and father. Fourthly, upon the heirs of father. Lastly, upon the heirs of mother. Notwithstanding anything contained in subsection 1, any property inherited by a female Hindu from a father or mother shall devolve in absence of any son or daughter of the predeceased, including children of any predeceased son and daughter, not upon the other heirs referred to in subsection 1 in the order specified therein, but upon the heirs of the father. So this is the first part. If the property is inherited by a female Hindu from a father or mother, in absence of son and daughter. The second part is a property inherited by a female Hindu from her husband. That will not come in our case. Now, it may come because that is the case of the plaintiff. This is the money inherited from the father. It's Mrinmoy's money.
All I was trying to find out, Mr. Mitro, whether what is his name, client's name, Mr. Bose's? Jyotirmoy comes within class 1 or class 2 heir of Mrinmoy.
Then yes.
Does.
Yes.
Class 2 heir.
Yes.
Of Mrinmoy.
Of Mrinmoy, yes.
Of Mrinmoy, which is Shamuli's husband's heir.
Yes. So, and this
he has interest. He can.
It's a large family.
This
so
has
as
to
the elder
this,
brother applies.
This has to be read along with 15.
Yes, where you couldn't produce an iota of evidence that it was inherited from your father.
It was inherited from my father. Now so the document, but yes, to sell a property in Bihar, the sale deed, the whatever the money came in, this is exactly the money trail. Exactly the same money got invested in the Citibank fixed deposit. There is no document.
Something, at least something, nothing at all.
Now there is one document, my lord, I can show you. There is a RBI Reserve Bank's deposit, which was initially done. But that is also another from one bank A to bank B. There was a Reserve Bank bond in the name of this lady, and that bond got matured, and then the money comes here. That document, I have to check it. So, other than that, now the learned judge has proceeded. If the character changes, I join issue melody. I'll say there are Supreme Court decisions which is saying that the court will have to trace the origin of the property. It is not whether the character has changed. Now, if the property is no more and it has been converted to a money, it doesn't really is a separate money kept in account. So it is the same money which I received from the sale of the property, and this is now in the bank. Now that is the only short point if I can show to the court.
Yes, you show whatever you want to.
Now I say that from the plaintiff side also, there is no document to show that this money is what was with Shamoli. But this Shamoli's money, came from her husband. It was inherited on the death of her husband.
Plaintiff need not. Plaintiff, all he needs to show he is an heir. He is entitled to apply for succession certificate.
That he is. That he is.
That is what we were trying to
that,
ascertain.
That he is. That he is. Is entitled to accession certificate. Now, my lord, on the principle that we'll trace the origin of this money. Now, the impugned order records one decision, which is the division bench of Andhra Pradesh High Court. There are two subsequent Supreme Court decisions, which is 2002 and 2022, which records that the court will have to try to trace the origin of the property. It is not if the property changes character. The issue is not whether the property has changed the character or not. The tracing the origin. Now, I'll just cite these decisions.
Mr. Mitru, anyway, we have 8 minutes. You may not conclude today.
Okay.
Let us record briefly what has been argued
Yes.
today. Ei Ishu, Ashun.
Yes.
This appeal is directed against a judgment and decree dated April 25, 2024, passed by a learned judge of this court in CS 191 of 2012 in a suit filed by the present respondent number 1. Paragraph. Shorn of unnecessary details, the brief facts of the case are that the respondent oblique plaintiff is the brother of one Mrinmoy Palchodhuri. Stop. Shamoli Palchodhuri was Mrinmoy's wife. Stop. The defendant number 2 in the suit is the sister of Mrinmoy's wife, sister of Shamoli. Shamoli, since deceased. Stop. Mrinmoy and Mrinmoy predeceased Shamoli. Stop. Shamoli died sometime in blank. Sometime in blank. Mrinmoy and Shamoli didn't have any children. Stop. Paragraph.
Shamoli passed away on 26th of July 2008.
Yeah, in July 2008. July 2008. Jyotirmoy, now, Shamoli died intestate. Stop. Jyotirmoy applied for succession certificate in respect of the properties left behind by Shamoli. Stop. The properties of Shamoli included a bank account held with Citibank, which branch?
Chorangi.
Citibank, Chorangi branch, wherein there was substantial sum of money in the region of rupees 26 lakh. Stop. Paragraph. Succession certificate was granted in favor of Jyotirmoy by the Alipur court. In a proceeding which Shamoli contested, which Shonali contested. আগে যেখানে ডিফারেন্ট নাম্বার 2 বলেছেন না ব্র্যাকেটে সোনালী করে দেবেন stop paragraph Jyotirmoy says that the factum of pendency of the application for succession certificate filed by him was made known to Citibank by writing a letter. Stop. After the succession certificate was granted in his favor, Jyotirmoy approached the bank for operating the bank account in the name of Shamoli. Said bank account. Stop. He was told that the money has been handed over to Shonali being the nominee of Shamoli. Stop. Paragraph. In the aforesaid factual matrix, Jyotirmoy filed the instant suit against Citibank and Shonali, claiming a money decree for rupees 26 lakh, na, 25, 29, 156.85. Paragraph. The learned single judge analyzed the evidence on record, which consisted of the deposition only PW1. One.
I have also given evidence. Plenty.
Defendant.
No, Citibank did not give.
Citibank did not.
Shonali herself.
Yes.
Which consisted of the depositions of the plaintiff, Jyotirmoy and Shonali. And Jyotirmoy and Shonali, stop. The learned judge came to the conclusion that the bank was in collusion with Shonali and wrongfully handed over the money in Shamuli's account to Shonali, notwithstanding pendency of Jyotirmoy's application for succession certificate. Stop. The claim form was not considered, the claim form submitted by Shonali was not considered with due care by the bank. Stop. The bank acted completely callously in the matter. Stop. Paragraph. The learned judge further held that a nominee does not become the owner of, does not necessarily become the owner of the money that the bank may hand over to him or oblique her. Stop. He oblique she receives the same as trustee for the legal heirs of the deceased in whose name the bank account was held. Stop. The learned judge concluded that Jyotirmoy, having obtained succession certificate from a competent court, he was entitled to that money. Stop. Accordingly, the learned judge decreed the suit in favor of Jyotirmoy and against Shonali in the sum of, in the sum claimed. Stop. A cost of rupees 1 lakh was imposed on the bank for having acted in unholy alliance with Shonali. Paragraph. Jyotirmoy, the bank and Shonali have all preferred separate appeals against the judgment and decree. Separate appeals. Stop. Paragraph. Jyotirmoy is a... Oh, sorry. The bank and Shonali have preferred separate appeals against the judgment and decree. Stop. Jyotirmoy has filed a cross-objection. His grievance is limited to the extent that having found that the bank acted in cahoots with Shonali, CAHOUTS, in cahoots with Shonali, the decree should have been passed jointly and severally against the bank and Shonali. Paragraph. We are yet to, we have heard Mr. Utpal Bose, learned senior advocate representing the Jyotirmoy. Stop. Today there is no further time. প্যারাগ্রাফ লিস্ট দ্য ম্যাটার, এটাকে শেষ করতে চাই, এর উপরের দিকে দিয়ে দেবে, ওই অ্যাপিল ফ্রম অর্ডারের আগে তুলে দেবে। ডিক্রি টপে আছে, ডিক্রিটা তো সব রোজ টপে থাকে না। কালকে উপরে থাকবে ডিক্রি, হ্যাঁ? টুমরো?
On Friday, only not tomorrow. If it is the top of the list, post lunch is okay. এমনি অ্যাপেলের সাইড আছে
কালকে কিছু ফিক্স আছে?
অ্যাপেলের সাইড আছে ফিক্স করে। Post lunch I will be here.
Post lunch may not be possible.
And Friday on top of the list.
Any day.
Friday অর্ডারের উপরে তুলে দাও। Yes, Friday before appeal from order.
Before appeal from orders.
The list the matter Friday, on Friday. Date দিয়ে দিন।
If I may very humbly just make one prayer for your consideration. Your Lordship has dictated everything perfectly, as your Lordship always does. Well, look, this account number was the subject matter of the succession certificate.
Yes.
So the succession certificate proceeding,
তাহলে এটা লিখো।
which was well aware.
Like we have heard Mr. Bose. He argued that the concerned bank account, which is the subject matter of this suit, was also one of the subject matters of the application for succession certificate before the Alipur court.
Which was never objected to by
Shonali, who was a party to those proceedings and contested the same, never took any objection, raised any objection. There too. Stop. Mainly, this is what you said.
Yes, this is your Lordship.
Otherwise,
everything is
yes,
there.
yes,
This is a very crucial piece of evidence.
He submitted that the learned judge has correctly analyzed the evidence on record and has rightly found that the bank was hand in glove with Shonali.
And did not take care and caution whilst.
Stop. The bank did not take due care and caution whilst disbursing the amount in favor of Shonali.
Very grateful.
তারপরে, there's no further time today. List the matter on. হাসছো কেন? Further time তো নেই তো।
I appear on behalf of the bank, my lord.
Marked কখন বললাম? না, marked কিছু না। ওটা at the top.
I appear on behalf of the bank, my lord. I am led by Mr. Ali. Whichever day your lordship takes it on Friday, we shall address your lordship.
Friday, yes. That's what we are doing. We are aware Mr. Ali is appearing. Yes.
Item number 4.
Grateful.
না, সেই সেম ইন্দুভূষণ দাস সেই ছিল না? No, sir, same name, Mr. Indubhushan Das. Indubhushan Das. This bar association list, there is no Indubhushan Das.
As per my instruction, my lord, my clerk tried to serve him several times, but he was not able to get his address.
You know Mr. Indubhushan Das? No. কি ঝামেলা? কি করবো তাহলে?
We had served upon the department, my lord, the appellants. And my lord, this matter was dismissed for default. They had not appeared on 2 successive occasions, my lord.
I see. We will serve a notice.
My lord.
কত নম্বর? 4 নম্বর আইটেম লেখো, কেউ আছে? This application has been taken out by the respondent for withdrawal of the amount lying deposited with the court.
With the registry, with the learned register.
Registrar General.
Register.
With the learned, that is with the court. With the court, in view of the appeal having been dismissed for default on
24th of April 2025.
April 24, 2025. Stop. From the paragraph, from the affidavit of service filed in court today, we see that the appellant, শুরু করেছি কিভাবে, this application has been ঠিকই আছে, ঠিক আছে. We see that the appellant has received notice of this application. Stop. However, nobody appears for the appellant, i.e. Digha Shankarpur Development Authority. Stop. Paragraph. We are told that the amount which was deposited along with an interest today stands at about rupees.
I'm not
Roughly
around 50 lakhs.
50 lakh. Stop. Paragraph. Let the department করবো না, learned registrar general. Learned registrar general survey. এটা কি original side matter? Oh, sorry. Let the registrar from original side serve a notice on Digha Shankarpur Development Authority intimating that this matter will be listed again on কতদিন বাদে রাখবো, 7 দিন, ঠিক আছে, তাহলে আরো বেশি দেয়। আজকে কত তারিখ বল? 23 করো তাহলে 6 তারিখে রাখো, August 6. Stop. On that date, if nobody appears for the appellant, this application is likely to be heard in their absence.
Great.
In its absence, there na. Cholo. You have it? Oh. কবেকার অর্ডার? বিলটা